And if I may draw your attention to para 4 at 1734.
Para 5?
Para 4.
4, all right.
At 1734. These were the points that were argued. That's why I want to place that on record. Para 4, if I may read.
Yes.
We now proceed to state the findings of the High Court on the various points argued before it, not in the order as finally recorded in para 98 of its judgment at page 1530, but in the order the points were urged before us by Mr. Lal Narayan Sinha, learned counsel for the appellants, that is the state of Karnataka. So they are as follows. So one, these are the points which were argued by the appellants, and these are the points on which the High Court had delivered its judgment. And these are the points. 1, the acquisition is not for a public purpose. 2, the compensation or the amount provided for or the principles laid down in the Act for payment in lieu of the various vehicles, permits, and other assets is wholly illusory and arbitrary. For the 2 reasons aforesaid, the Act is violative of Article 31(2) of the Constitution and is a fraud on it. It is therefore null and void. If I may just pause here, at this point of time, Article 31 existed in the Constitution, and the entire attack was on the ground of violation of Article 31. Point 3. The acquisition of contract carriages with interstate permits and other assets pertaining to such operators is ultra vires the legislative power and the competence of the state legislature. Here, the argument was it is an extraterritorial legislation. And point number 4. 4 is important. This is the only issue with respect to Article 31C. Article 31C does not bar the challenge to the Act as being violative of Article 31(2) of the Constitution, as there is no reasonable and substantial nexus between the purpose of the acquisitions and securing the principles specified in clauses B and C of Article 39. So as far as we are concerned, this is the only issue that has a bearing, and it's a very limited argument that 31C does not bar the challenge because there is no nexus between the purpose of the legislation and the principles of 39C, B, and C. Ultimately, Your Lordships, there is also a passing reference towards the end of para 15, where the 4 judges, just before para 16, the 4 lines of para 15, the last few lines, 3 lines of para 15, where they say, when we say so, we are not taking into account the effect of 31C. This is the majority, inserted in the Constitution by the 25th Amendment, leaving out the invalid part. Now, Lordships, please see para 17. The last 7 or 8 lines of para 17, just before para 18, where the arguments of Mr. Lal Narayan Sinha are noted. So it would be the 6th line from the top. Mr. Lal Narayan Sinha, learned counsel for the appellants. Your Lordships has that. Took a very just and proper attitude in advancing an argument before us, which would take away the basis of the High Court judgment in this regard. With respect to each and every relevant section on the question of payment of the amount in lieu of the property acquired, he suggested such a reasonable, harmonious, and just construction by the rules of interpretation that we found no difficulty in accepting his argument, rather were glad to do so. The other side on the interpretation so put, which we are going to mention hereinafter, felt satisfied to a large extent. Mr. Sinha also advanced some argument with reference to the valid part of Article 31C, read with clauses B and C of Article 39, but very wisely did not choose to heavily rely upon it. On the interpretation of the statute as canvassed by him, there hardly remained any necessity of it being a reference to Article 31C, read with 39B and C. So the court here says there is really no need to go into that because we are accepting his interpretation of the statute. And ultimately at para 27,
Can you just read the sentence previous to the one that you started off with? That will put the things in perspective.
yes, they would not only be paupers.
Something I think to do with Mr. Sen. Many of them were.
Many of them were plying their contract carriages, having taken loans of considerable sums of money from the various financiers on hire purchase system, for whom also Mr. A.K. Sen appeared and argued before us. They would not only be paupers, but huge liability will remain on their shoulders if the interpretation put by the High Court were to be correct. And thereafter. Now, para 27, only to show that here, if I just read para 27, on the interpretations aforesaid, which we have put to the relevant provisions of the Act, it was difficult, rather impossible, to argue that the amount so fixed will be arbitrary or illusory. In some respects, it may be inadequate, but that cannot be a ground for challenge of the constitutionality of the law under Article 31(2). So they say that the law is not ultra vires Article 31(2). And ultimately, this is reiterated in para 32. I don't want to repeat. Para 37. The last few lines of para 37, which your lordships have noticed yesterday, but I just want to place it. Where it begins from since. The first 5-6 lines really don't have to do with this aspect at all. Since. Para 37. Since we have upheld the constitutional validity of the Act on merits by repelling the attack on it by a reasonable and harmonious construction of the Act, we do not consider it necessary to express any opinion with reference to Article 31C, read with clauses B and C of Article 39 of the Constitution. Our learned brother Krishna IRJ has prepared a separate judgment specially dealing with this point. We must not be understood to agree with all that he has said in his judgment in this regard. So presumably the majority or the 4 judges wrote their opinion. The opinion of Justice Krishna Iyer was placed before it. And then the 4 judges have specifically said, we do not agree with what he has said. As far as Justice Krishna Iyer is concerned, if you compare the questions posed by the majority at para 4 and compare that with para 41 and 50 of Justice Krishna Iyer's judgment. Para 41, this should be at page 1750. If I may just straight away come to the 7th or 8th line from the top of para 41. Secondly, does a legislation qualify for immunity under Article 31C, read with Article 39B, only where the scheme is to divide and deal out to a plurality of persons to disperse, diffuse, or scatter ownership and control of material resources of the community compulsorily taken by the state? That's one meaning. And or does it embrace distribution with a wider connotation of removal from the private sector? So if I may pause here, the 2 interpretations that he is now looking into. One, where he says, is it only to divide and deal? And the second interpretation, or does it embrace distribution as in including removal from the private sector? That is acquiring. And this is only in his judgment, nowhere else. And allocating in the public sector, dividing and arranging, separating and allocating, acquiring from individuals, and making over to the collective institutions or state organs acting for and in the interest of the community according to the state plan or policy decision on the scheme of distribution and allocation of resources among the different sectors of economic activity so as best to subserve the public good. How, in short, do we decode distribute in Article 39B, illumined by Article 38? If your lordships may just come to the few lines on the next page after R.C. Cooper is mentioned. Can the theory, third line, can the theory of illusory compensation be apocryphal or be exaggerated to apply to diminished compensation as a revised reincarnation of adequate compensation, still menacing projects of nationalization? How do we conceptualize material resources and public purpose in our current constitutional setting. And thereafter, your lordships may see para 50. This is at page 1753. Just before para 51, there are questions which are now framed by Justice Krishna Iyer. And if your lordships were to compare this, most of this is not present in the questions framed or even argued. If you see para 4, that was all that was even argued. And these are the questions. And if your lordship specifically sees question 2, what are the pervasive ambience and progressive amplitude of directive principle in 39B and C in the context of nationalization of public utilities? 2A, can state monopoly by taking over private property be a modus operandi of distribution of ownership and control of the material resources of the community to subserve the common good within the framework of Article 39B? 2B, are distribution and nationalization antithetical or overlapping? 2C, what is the connotation of the expression material resources? Can private buses be regarded as material resources of the community? Thereafter, your lordships have seen para 80 and 81 yesterday, so I will not repeat that.
Just quickly, just take us through it, since, it will help you to...
Yes.
Formulate it, but put it in context and perspective.
Yes. So para 80, this would be at page 1770. This takes us to the non-negotiable minimum of nexus between the purpose of the acquisition and Article 39B. Article 39C was feebly mentioned, but Article 39B was forcefully pressed by the appellant. Better read Article 39B before discussing its full import. Article 39B is reproduced. The keyword is distribute. And the genius of the article, if we may say so, cannot but be given full play as it fulfills the basic purpose of restructuring the economic order. Each word in the article has a strategic role and the whole article a social mission. It embraces the entire material resources of the community. Its task is to distribute such resources. Its goal is to undertake distribution as best to subserve the common good. It reorganizes by such distribution the ownership and control. 81. Resources is a sweeping expression and covers not only cash resources, but even ability to borrow, credit resources. Its meaning given in Black's legal dictionary is money or any property that can be converted into supplies, means of raising money or supplies, capabilities of raising wealth, or to supply necessary wants, available means or capability of any kind. After quoting the Black's dictionary, now this is his judgment, and material resources of the community in the context of reordering the national economy embraces all the national wealth, not merely natural resources, all the private and public resources of meeting material needs, not merely public possessions. Everything of value or use in the material world is material resource, and the individual being a member of the community, his resources are part of those of the community. To exclude ownership of private resources from the coils of Article 39B is to cipherize its very purpose of redistribution the socialist way. A directive to the state with a deliberate design to dismantle feudal and capitalist citadels of property must be interpreted in that spirit, and hostility to such a purpose alone can be hospitable to the meaning which excludes private means of production or goods produced from the instruments of production. Ms. Shri A.K. Sen agrees that private means of production are included in material resources of the community, but by some baffling logic excludes things produced. If a car factory is a material resource, why not cars manufactured? Material may cover everything worldly and resources, according to Random House Dictionary. Takes in the collective wealth of a country or its means of producing wealth, money or any property that can be converted into money assets. No further argument is needed to conclude that Article 39B is ample enough to rope in buses. The motor vehicles are part of the material resources of the operators. So, number one, your lordships, there is no precedent as such. He has relied on the dictionary meanings of various words and come to the conclusion.
the view only of a plurality. It's not the majority
Yes.
in any case.
So, Lordships, I have two.
Concurring opinion.
The concurring.
It's also
Yes, it's
concurring opinion.
it starts by saying it's a concurring. Yes.
Majority interpreted the provisions of the Act.
Yes.
Felt that, this had broadly satisfied all parties. Mr. Lalnarayan Sinha's argument was broadly, they said it's fair. On the interpretation of the Act,
Exactly.
it is not necessary to go into the 39B.
Exactly. So the limited point I'm making is,
Justice Krishna has that.
yes, that issues. Therefore, the problem, the reason why this is important is because this opinion then gets resurrected, as your lordships have seen, in Sanjeev Kokh, where a bench of 5 judges now decides that this is the law. So that would be the next step that I'll show your lordships.
The fact remains that in this case, the High Court struck down the nationalization issue, saying that the one is on public purpose, which has been reversed by this court.
Yes.
Secondly, that Article 39B was not justified in the instant case.
Yes.
That's why the petitioner succeeded in the High Court.
Yes.
It is in the state appeal
Yes.
that there is a reversal.
Yes. And
this is a concurring opinion.
yes. But while reversing, the majority says we need not go into it because we otherwise find that there is no violation of 31.
It's not even.
That was the paragraph I read. Right. So if I may now take your lordships to the judgment in Sanjeev Kokh.
For all comparing in the sense what is said. What additional reason?
I'll only read one para. I don't want to repeat what has been said.
Also saying the same thing, and I'm also saying the same thing.
This is page 2294 of volume 5.
We are not. Student.
I only want to read para 19. Para 19 at page 2313. May I read?
Which para you said?
19. At page 2313. May I read, Your Lordship? Para 19. The nationalization of the coking coal mines and the coke oven plants was with a view to reorganizing and restructuring such mines and plants for the purpose of protecting, conserving, and promoting scientific development of the resources of coking coal needed to meet the growing requirements of the iron and steel industry and for matters connected therewith or incidental thereto. We do not entertain the slightest doubt that the nationalization of the coking coal mines and the specified coke oven plants for the above purpose was towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. The submission of Shri A.K. Sen was that neither a coal mine nor a coke oven plant owned by private parties was a material resource of the community. According to the Learned Council, they would become material resources of the community only after they were acquired by the state and not until then. In order to qualify as material resources of the community, the ownership of the resources must vest in the community, that is the state. A legislation such as the Coking Coal Mines Nationalization Act may be a legislation for the acquisition by the state of coking coal mines and coke oven plants belonging to private parties, but it is not a legislation towards securing that the ownership and control of the material resources are so distributed as best to subserve the common good. Shri Sen invited our attention to the emphasis which Krishna Iyer J. laid on the word distribute occurring in Article 39B of the Constitution in State of Karnataka versus Ranganath Reddy. and Krishna Iyengar's description of it as the key word and the dissertation on the genius of the article. Sri Sen urged that if the word distribute was given its proper emphasis, it would inevitably follow that material resources must belong to the community as a whole, that is to say, to the state or the public, before they could be distributed as best to subserve the common good. Since those material resources which belonged to the state only could be distributed by the state, Sri Sen argued that material resources had first to be acquired by the state before they could be distributed. A law providing for acquisition was not a law for distribution. We are unable to appreciate the submission of Sri Sen. The expression material resources of the community means all things which are capable of producing wealth for the community. There is no warrant for interpreting the expression in so narrow a fashion as suggested by Sri Sen and confine it to public-owned material resources and exclude private-owned material resources. Thereafter, if your lordships comes to the next page, same para 19 in continuation, the 6th or 7th line from the top. When Article 39B refers to material resources of the community, it does not refer only to resources owned by the community as a whole, but it refers also to resources owned by individual members of the community. Resources of the community do not mean public resources only, but include private resources as well. Nor do we understand the word distribute to be used in Article 39B in the limited sense in which Sri Sen wants us to say it. It is used, that is, in the sense only of retail distribution to individuals. It is used in a wider sense so as to take in all manner and method of distribution, such as distribution between regions, distribution between industries, distribution between classes, and distribution between public, private, and joint sectors. The distribution envisaged by Article 39B necessarily takes within its stride the transformation of wealth from private ownership into public ownership and is not confined to that which is already public owned. And this is important, Your Lordships. The submissions of Sri Sen are well answered by the observations of Justice Krishna Iyer. And then paras 80 and 82 said that so the submission is that there has to first be an acquisition of the property because 39B deals only and only with distribution. It cannot be used in aid of statutes where the property of a private individual is being acquired.
Actually, Ms. Shukla, the philosophical approach of both Justice Krishna Iyer and Justice Chinnappa Reddy is this. If you look at the purely capitalist concept of property, the capitalist concept of property attributes a sense of exclusiveness to property. This is my pen. It's exclusively mine. Nobody else can use my pen. The socialist concept of property is the mirror image which attributes to property a notion of commonality. Nothing is exclusive to the individual. All property is common to the community. That's the extreme socialist view. Our directive principles, we must understand, have their foundation in the Gandhian ethos. The directive principles are really in pursuance of the Gandhian ideology. And what is that ethos? Our ethos regards property as something which is held in trust. We don't go as far as to adopt the socialistic model that there is no private property at all. Of course, we have private property. And that concept of trust, which is now being applied, in the context of, say, sustainable development, in the environmental context. Maybe it's in my mind because I was teaching a class this morning on sustainable development and climate change. But, our concept of property has undergone a very subtle change from either the extreme capitalist perspective or the extreme socialist perspective. We regard property as something which we hold in trust. We hold the property in trust for the succeeding generations in the family. But broadly, we also hold that property in trust for the wider community. That's the whole concept of sustainable development. That property which we have today, as today's generation, we hold in trust for the future of our society. That's what you call as intergenerational equity, right?
Yes, sir.
So, it would be, to my mind, it would be a little dangerous to have this dichotomy that 39B only now, one more thing before I come to it, because I'm sorry to break your link, but I'm getting old and I might miss this, half an hour later. See, both Justice Krishna Iyer and Justice Chinnappa Reddy deal with two aspects when they deal with 39B: the origin and the beneficiary. The argument before the bench in Ranganath Reddy was that the origin must be in the community for 39B and C to apply. If something does not originate in the community, then 39B can never apply. Second argument was that distribution postulates that you will distribute it to individuals. If you're not distributing it to individuals, then 39B will not apply. They deal with both these arguments at a philosophical level by saying that even if something does not originate in the community, right, if it is property of the nature which has a bearing on the welfare of the community, 39B is capable of application. Second, that is the origin. On the distribution, they say that even if it is not being distributed to individuals, for instance, nationalization, you take over property, vest it in a state corporation. It's not a distribution to an individual. That concept is also within the purview of 39B. Because why were you nationalizing? You were taking over private property, but using that property for interest for the wider society, but it is not being given, it's not being distributed. So they deal both with the source or the origin, and they deal with the distribution aspects in these two judgments. It may be a little extreme to suggest that material resources of the community only means resources we do not have their origin in the private property of an individual. I'll tell you why it will be dangerous to take that view. Take simple things like mines, forests, even private forests. For us to, for instance, say that, look, the moment a forest is a private forest, 39B will not apply, would be, and therefore it's hands off, would be extremely dangerous a proposition. It depends upon context, as Brother Dulia said yesterday to us when we were discussing on the bench. It depends on the context. In a given case, a private house.
Zamindari land.
Yeah, exactly. Zamindari lands. That was the whole basis of our agricultural ceiling laws.
Yes.
Whether it was the UPZA and LR Act or the Maharashtra Agricultural Ceiling on Agricultural Lands Act. So we must have regard to, we must put ourselves back in the 1950s when the Constitution was made. So the Constitution which was intended to bring about a sense of social transformation. And that was the transformative ideal of the Constitution. Whether this act is valid is a completely different issue.
Yes.
Is a completely different issue. That will ultimately be decided. But we can't say that 39B has no application once property is privately held property. Because the societal demands, the societal welfare, the need for redistribution, considering the societal perspective. So it may be airwaves, it may be water, it may be forests, it may be mines. In some areas, probably the dividing line becomes very clear. Just taking somebody's flat. Possibly, you may have a point on that. But we must understand that 39B has been crafted in a certain constitutional ethos. That the Constitution was intended to bring about a social transformation. Therefore, we shouldn't therefore go as far as to say that the moment private property is private property, that 39B and C will have no application.
So, Lordships, may I just...
The second thing which I wanted to tell you was that whether 39B and C can have two consequences in our constitutional law, right? One, the moment a law is enacted to give effect to 39B and C, that law is immune from challenge under Article 31C, unless you come to the conclusion that the law has no nexus to 39B and C, which was what was struck down in Keshwan and Bharati. The moment a law is in furtherance of 39B and C, that law has an immunity under 31C. But even if the law does not have an immunity under 31C, right? Even if the law is not immune from 31C for some reason, say some bench comes to a conclusion that 31C does not exist on the statute book today. Even so, the fact that the law has been made in pursuance of 39B and C may be an index of its reasonableness. That's not just 39B and C. The fact that Parliament or the state legislature has enacted a law to give effect to any of the directive principles is an index of its reasonableness. But reasonableness postulates that it's subject to or amenable to judicial review. What 31C did was, it completely excluded from judicial review on grounds of 14 and 19,
Yes.
leaving open again now other constitutional challenges.
Right.
So I think that's where the matter really lies in that sense.
So Ashok sir, just
Today, Mr. Andarjuna didn't argue on 31C. We'll
Yes.
ask the other side when we are on 31C, because one thing which we are thinking aloud, actually, not just for you, but for the other side when they take up their view. The argument that this law has no nexus to 39B and C, right, postulates that 31C is valid, because that whole argument that the law on your side, that the law has no nexus to 39B and C, postulates that because it has no nexus to 39B and C, therefore the law is not protected by 31C.
yes,
Which means that 31C is there,
exactly.
but because the law has no nexus to 39B and C, therefore this law is bad,
Yes.
right? But if 31C
Yes.
does not exist at all,
Absolutely.
right?
Yes.
Then the 39B and C argument will still apply.
But independent of 31C.
Independently,
Yes.
on the ground that the law is not immune from challenge under Article 14 and 19,
Exactly.
but the law is presumed to be reasonable because it is giving effect to 39B and C. There are two different things. One is an immunity from constitutional challenge. The other is the index of the reasonableness of the law.
Absolutely.
So I'm subject to hearing the other side. Now, one last thing, Mr. Attorney, Mr. Solicitor and Mr. Dwivedi, look at it this way. The 31C argument, the 31C argument, there are succeeding constitutional bench judgments of our court which have taken the view that 31C still continues to exist. Minerva takes it, Vamanarao takes it, subsequent decisions have taken it, though Mr. Nariman argued in the referral order
That it's on a
this was only
concession.
on a concession.
Yes.
That this was on a concession.
Yes.
Now, therefore, that 5, the correctness of the Constitution bench implicitly holding that 31C still continues to be on the Constitution, the correctness of it, if it has to be tested, which was what Mr. Nariman argued, we'll have to go to 7. We'll have to go to 7 judges. 9, the reference to 9 came only because of Ranganath Reddy,
Yes.
Justice Krishna's judgment, which was then adopted in Sanjeev Coke. Therefore, the bench felt, let's go to 9.
Yes.
But even if we don't go into 31C, 31C will have to be decided. Whether
Yes.
31C is on the statute book will have to be decided by a bench of 7 judges.
Yes. Absolutely.
Now, the question is whether we should leave it for a future day for some 7-judge bench to decide it, or decide it here, because we are certainly a bench of 9 can certainly decide it. Why leave the law in a state of uncertainty?
On our side,
Because
speaking
75
for
years
myself.
down the line, for this court to say that 31C does not exist
Yes.
will be a very radical constitutional consequence. So all the laws which have been protected under 31C will become vulnerable. Therefore, instead of leaving this to a future, litigation before 7 judges, you may also reflect on it that perhaps we should resolve it and put,
We're okay with it. Before that.
Request.
may have to hear them on the 31C argument, and we'll allow you to respond to it, because, leaving things in constitutional uncertainty is also not good thing for the nation.
It was not uncertain. So far as reflect and respond. My immediate response is there is no uncertainty about 31C.
We have 5 judges have held, though, according to Mr. Nariman, as he then Mr. Pari Nariman,
Yes.
that this was on a concession.
But it is not so. But be that as it may, nobody has doubted 31C now.
It is not so. Then is it not really desirable that a bench of 9 should put an end to this controversy? Because otherwise what happens is a whole host of laws become just vulnerable to challenge. We are not concerned about the merits of this law which is in challenge before us. That's the least bit of a problem, the least bit of the worry. Whether this law is upheld or struck down does not really, in that sense, alter the nation's constitutional fabric.
Correct, correct. My lord, what possibly, my lord, Mr. Nariman also argued, and what was the point in controversy was not whether 31C survives or not. The question was partly 31C having been set aside, whether there would be a revival of what is already gone. That's all.
That's the point.
That's all, not the validity of 31C.
The revival. Because what happens is 31C in Keshwanand Bharti is struck down, only the last part is struck
Correct.
down.
Yes.
Which said that whether the law actually gives effect to 39B and C would not be inquired into by any court. That was
So
the latter part.
judicial review was taken away, which is settled.
Keshwanand Bharti said, no, that part is unconstitutional. Whether the law actually gives effect to 39B and C is reviewable. So Keshwanand Bharti strikes it down. Therefore, the substantive part of Article 31C is upheld by Keshwanand Bharti. Now, what Parliament did was in the 42nd Amendment, they expanded the ambit of 31C by including not merely a challenge on 14 and 19, but on all the fundamental rights.
Part 3.
Right?
On all directive principles.
On all-
Instead of
on all
only
directive
39 BNC.
On all directive principles, right? Instead of 39B and C, they said all directive principles. That is struck down in Minerva Mills. Now, what is the consequence of the decision in Minerva? Does that only strike down the expansion of the ambit of 31C to all directive principles?
Yes.
Or does it leave intact 39B and C? Now, if your contention is the latter contention.
Yes.
39B and C, it still continues to be valid. But is it not important that we deal with that and decide it?
But the difficulty is, my lord, neither anyone has addressed, my lord, that your lordships can permit addressing. We have also not, my lord, examined from that point of view, my lord. Because according to us, my lord, and at the outset I pointed out that the controversy before this bench is limited.
But you know, what's going to happen is this will go back right away before 7 judges to argue that. And what we are doing is, we are dealing with the offshoot, namely 39B and C,
Yes.
without dealing with the mother, which is 31C.
But
If 31C, if they are right, for a moment, hypothesis, if they are right, that 31C does not exist on the Constitution today by virtue of the judgment in Minerva Mills, then whether the law is protected under 31C as giving effect to 39B and C does not arise at all.
correct, my lords, but nobody has doubted that proposition, which may, my lord, give rise to a re-examination by the larger bench.
The first referring order specifically raises this as Mr. Nariman's argument. In the second and third referring orders, what happened was the focus shifted to
39B.
39B and C. But the fact that Mr. Nariman, and he's observing us from heaven, the fact that Mr. Nariman raised this issue about 31C is squarely a part of a referring order. And that will have to be Seven judges at the minimum.
Five.
Decided by seven.
By
cannot-
Five, my lord.
No,
By-
it has to
seven.
go before 7 because it has been decided by 5.
It is 3.
By a
The
bench of
first
5.
reference is 3.
No.
Minerva Mills is 5.
Minerva Mills is 5.
Minerva Mills is 5.
Minerva is 5. Vamanarao is 5.
This is the first question.
This very question has been referred by 5 to 7.
My sister just with her permission, I'll just read out. The first question which Mr. Zal had raised yesterday was whether 31C of the Constitution survives after the judgment of this court in Minerva Mills, reported in so-and-so, striking down Section 4 of the Constitution, 42nd Amendment Act, 1976. Briefly, what they are arguing, they're not saying that they are right. They say that when a constitutional provision is substituted by a constitutional amendment, and that substituted constitutional amendment is struck down, that does not result in the revival of the original provision.
Yes.
Your answer to that would be, and I presume it, we have not heard you, is that when a constitutional provision is substituted by another constitutional provision to expand the ambit of that constitutional provision, then the striking down of the subsequent constitutional amendment on the ground that the expansion was unconstitutional.
The remaining part remains.
It will not affect the original. It will
Erase.
not be, because this was not an absolute substitution. This was an expansion. Expansion of the ambit of the protection which Article 31C gave. And the original provision having been upheld in Keshwanand Bharati, surely the impact of a subsequent smaller bench of 5 cannot affect the validity of the provision in Keshwanand. That's your argument. That's the point that we have to deal with. But, you know, honestly,
It was our argument, presuming 31C to be the subject.
Yeah, because on your argument on 39B presumes that 31C is valid. Now they are raising an issue as 31C is not valid.
Well, they are raising, my lord, but the court has never, my lord.
You know, I agree with you.
Your lordship, my lord, I can say one thing.
First referring order itself refers to this.
But my lord, thereafter that is given up, my lord, by every larger benches. Your lordships, my lord, sitting in this combination.
Given up actually.
My lord, your lordships, in my lord, one line answer. In this combination, your lordships can take up, my lord. I am not on that technicality.
Even if the Attorney General or the Solicitor General is to say today that he is still there, there will be a question by somebody, as was done, that it is a matter of concession. So should there not be a clarity on what is a very significant part of the Constitution?
Lord, let us, my lord, have, my lord, the.
One thing, of course, the other side, as the Chief Justice has rightly said, they had not had the opportunity. In fact, the discussion which is emerging today might have taken them a bit of a surprise. So I think that will have.
Actually, you know what happened was yesterday.
One more thought.
You know, yesterday Mr. Andarjuna was ready on 31C. Mr. Devarajan was to argue 39B. We tell, and Samir also. We told them that we are not going into 31C.
And my lord, my lord, I'll just add.
Among the pigeons yesterday, you see, so that's why they were.
Lord, and I would add, we were ready to persuade your lordships that 31C does not arise, and we could.
Mr. Solicitor, we are more than willing, amenable to persuasion that look, 31C does not arrive.
No,
the argument of Mr. Nariman in referring order 1, there's no substance in it. Please don't. But then we can at least say, if you are right on that, we will say that the continuation of 31C is now a concluded doctrine in our jurisprudence, so that we lay it down for the future, if you are right. That, you know, 31C, that there is no though it was raised by Mr. Nariman, and that was the basis for one of the reasons for referring it to bench, a larger bench, and referring order 1, that there is no substance in it. And then, you know, that attains finality unless somebody decides to refer.
Can we, my lord?
You know?
First part of
Can we respond, my lord, after consulting?
In which case, after we've heard your submissions on 39B, we'll hear them on 31C. Mr. Andarjuna has broadly argued it, and then we'll hear him, you know, intensively for a couple of hours and hear your response on it.
One thought process. Regardless of 31C, if 31C has not even invoked 39,
Sorry?
if 31C has not referred to 39 at all, I'm just looking at it. Now, the law is that the directive principle state policy, any action, state action taken in pursuance of state policy, are presumed to be in public interest.
But 31C refers to 39B and
I close my eyes to 31C for a minute.
Yeah.
So 39B will still be a support, a framework of support for sustaining this law, without reference to 31C.
That I said when I was explaining it. It should be reasonable.
Exactly.
That I said right.
So it's only
that
all
even
these.
if the law is not protected by 31C, the fact that the law is in furtherance of 39B and C is an index of its reasonableness, isn't it?
Therefore, whether the court should go into a 31C argument.
But 14 and 19 would be excluded if 31C protects the law. Then they will argue everything else, 300 and A and 21 and all. That's then the nature of the challenge is constricted then before the regular bench.
And if I can just add, the second reference order also mentions the 31C issue. That 5 to 7 also mentions.
Going into a 31C, I understand the reason, the raison d'etre why the court would like to put in end to any controversy whatsoever. But I think we need to
You see, what
address the
happens
court
is
on a very
as-
larger
As
framework.
Samir is saying, the second order refers to 31C. The reference to 9 comes about only because of
Mafat
Ranganath Reddy being 7 judges.
That's right.
and
Right.
Mafat Lal.
But therefore, part of the
And
challenge
Mafat Lal.
Mafat Lal.
Mafat Lal, 9
Mafat being
judges.
9.
Mafatlal.
Mafat Lal being 9. But they didn't refer it to 11 for the reason that Mafat Lal, that observation is obviously an obiter.
No, my lord, it is not, my lord, please don't say. That's our argument. We will persuade your lordships, it is not an obiter.
Mafat Lal are invited to get into.
Lord, your lordships have possibly preempted our argument. And, my lord, the reasons are simple. The Attorney General argued, findings are recorded, and obiter is not dealt with by the concurring or dissenting judgment. Even the dissenting judgment deals with it.
So the attorney general must do justice to it now.
All right. Therefore, we will take your argument that, Mafat Lal concludes it. Therefore, 9 will deal with 39B and C, but their argument on 31C will have to be dealt with by whom? Somebody will have to deal with it, by at least 7.
Lord, we are before the Honorable Chief Justice, bench presided by the Honorable Chief Justice. My lord, no technical arguments can weigh.
He'll say that, look, my argument on 31C has to be, somebody has to answer it. 5 can't answer it.
Correct.
After we decide this matter, we'll say now refer that to 7. So after this round, again it'll go back to 7.
My lord, correct, my lord, but thereafter,
Stop them from having their day.
my lord, thereafter the benches, larger benches than, my lord, the one which referred, my lord, felt that it is not necessary. My lord. It's not that, my lord, without
It's not rejected. You see, the 7 judges, while referring it to 9, didn't reject the 31C argument which they are making. They just referred to this
by
because-
non-referring, they have rejected, my lord. My lord, they had an option of referring everything.
31C will have to deal with actually.
The reference is by implication. Cannot. Not referring to 31C over and over again.
My lord, there were 5 issues, they refer 4, meaning thereby, my lord, they have not referred the 5th.
We settle it. We'll have to deal with
Lord,
it.
your lordships can settle several issues which might even incidentally arise academically. Academically, my lord, I can raise 5 issues.
So we'll have to go.
Lord, I can-
Mills, actually. What
Lord-
was the ground on which Minerva Mills struck down 31C? If Minerva Mills says, as I believe it does, that this expansion of 31C to include all directive principles is unconstitutional, then Minerva Mills has left the substratum of original 31C intact.
As affirmed by Keshavananda.
No, Minerva Mills is
Second,
subsequent
and
to.
look at the consequence of other.
Correct, but Keshwanand Bharti is 13 judges, my lord.
Another thing, Mr. Solicitor, look at the consequence of, suppose we were to accept their submission, that 31C is not in the statute book today, right? All that it means is what? What is the consequence? That Parliament will have to bring about an amendment to reinstate the original 31C, which has been upheld by Keshwan Bharti, which is what you are suggesting.
My lord, it's not that, my lord, your lordship knows, my lord, on the practical grounds, it's not.
Practical, no. We are not on the practical aspects. We are on the constitutional aspect. This does not prevent Parliament, no. Parliament can just, can revive and restore 31.
My lord, let us, my lord, confer and respond,
So,
but, my lord,
even assuming that-
academically,
It's a question of the process, following it again.
my lord, the academically, my lord, we can raise 5 more grounds, my lord. Would the honorable 9 judges bench, my lord, invest time on something which is not referred? But, my lord, will respond, my lord, after.
It's part of the whole, both the questions.
According to us, it is not, my lord. I can again persuade your lordships that 31C is not very consciously referred to the larger bench.
All right, what we will do is this. Now they are virtually completing their arguments on 39B. Now Ms. Babar is arguing, one or two more counsel, 5 minutes we're giving them. After they have concluded that, you address us on, of course, their submission on 39B. And please tell us, argue on why the 31C issue does not arise before the 9-judge bench. Not on merits, not on merits.
Lord, I already did that, my lord, and your lordships were, according to me, persuaded.
You can take 10 minutes, you can argue that issue.
No, in other words, what is the consequence of the judgment in Minerva Mills
Correct.
on
No,
31?
that is not really the question, my lord, which is troubling the, my lord, the Chief Justice.
Because
I don't know why why there is some little
No,
reluctance.
no, reluctance.
The judgment.
There is no reluctance on our part. My lord, that means, my lord, few more weeks. That's the only.
Few more weeks, I mean, another 2 hours on their side.
There's no reluctance.
That reference came 27 years ago. Now, the judgment which have come after that have clearly put that reference to rest tangentially without having taken up the question, but clearly it's been answered.
And tell us that,
The NJC judgment covers it fully.
Yes, my lord.
but then if you are right on that,
Yes,
please
then-
tell us that so that when a bench of 9 puts its finality, there is a certain degree of finality in the law, which is good for the nation.
My lord, I'll first address on that. But NJSC, in my note which I read yesterday, I didn't read it. My lord, I have quoted NJSC
That's
paragraph.
what we are saying, that please show us that, because then there is some degree of finality for the High
There is
Court.
no reluctance, my lord, kindly appreciate, but there is no reluctance before a larger bench, that too presided over by the Honorable Chief Justice of India. No technical plea referred, not referred, would arise, my lord, can be raised.
And see, as we told even Mr. Andaruna yesterday, we stopped him we said, look, we are not going to reconsider the validity of 31C based on Coelho, because that has attained finality in Keshwanan Bharati. We want that to stand. We don't want to open up the canvas, because in constitutional matters, just needlessly opening up the canvas can cause grave constitutional uncertainty. We'll be the last to do
Whenever
that.
your constitution comes closer to 13 judges, that makes all of us nervous. We'd like to keep that as a.
Well, 9 is not very far from 13, that's what he wants.
So,
I would welcome reference to 13.
there's a great deal to be said in
Not to be
the
50.
sense of stability and continuance of the same position of law. No position of law is perfect. Stability in a nation is very important, even in the constitutional fabric. So yes, we'll hear Ms. Babar now. She'll conclude
But we will address on, my
and
lord.
address us on why the 31C does not arise in.
And, my lord, with a caveat and with a clarification, there is no reluctance to answer that question. Genuinely, my lord, it doesn't arise. That's the.
actually just
That would be now necessary is took away the sale yesterday from the argument that was to be advanced.
Lordship.
So all that will be necessary now is to take into account that this argument is also being advanced.
Lordship.
So Ms. Babbar is on her legs. She will have to tighten her belts, raise the bar a little bit like they do in high jumps, and then also take in the argument of 31.
Lordship. We'll do that.
Yes, your lordships. We would request,
Now you've shown us both Justice Krishna's and
yes,
Justice Untwalia.
and that the argument, and the fact the arguments of Mr. Sen were rejected solely on the strength of the judgment of Justice Krishna Iyer.
Lord, in that
That's the
case,
other
well,
point
let them finish everything and we argue everything. Rather than doing
We
it,
have the right to open as far as 31C is concerned.
Online. That is there.
is there?
But I am here, my lord. I would prefer this matter of great importance to argue in person, my lord. I'm very sorry, my lord. I
Place that you are sitting in,
yes, my lord.
is it the same chamber that your illustrious father used to sit?
Lord, in fact, the very spot that I'm sitting in is that spot. So, Lord, your lordship is absolutely right, my lord.
Very, very, very important and significant chair, if I must say so, in the judicial parliament.
Lord, I am deeply honored by your lordship saying that.
Should be more effective if he addresses from that chair.
Lord, I leave it up to your lordships, my lord. But Lord, I am actually heartened to hear that your lordships will hear me on the 31C point. Lord, my only request would be, Lord, since the matter is of such importance, Lord, I would prefer to be there physically. I think the schedule would permit that I will be there tomorrow morning before your lordships.
You are fully seized to the matter, and we've heard the most significant matters, online. There's no difficulty. If you feel that we have been handicapped or you have been handicapped, we'll give you a little accommodation. No problem.
I am deeply obliged, your lordship. Deeply obliged. I'll be there first thing in the morning for this argument. If that suits your lordship.
We'll see as soon as they conclude. You be mentally prepared that we'll start with 31C once Uttara finishes.
39B first and there. Instead, my lord,
Would you
let
like to respond to 39B first?
My lord,
Together, my lord.
Lord, what all of us are, my lord, head item is,
Fair enough.
let
Then
them
it's,
argue everything,
all right.
we also respond in everything.
Fair enough. That's better. Yes, anything else now?
Yes, just a few short
But we'll
points.
have to update our notes also suitably. Right.
Just only on notice. Uploaded everything.
May I just inquire, my lord, 31C will be after the 39B arguments conclude?
No, no, well, that would be too piecemeal, my lord.
We'll start immediately after the next two lawyers are done. We'll hear you immediately. We'll start with that.
Very good,
Start with your,
very good.
and then Samir is also there. Samir Parakh is also there.
Very good.
We have, we'll do it. We deleted that 31C arguments from the written notes also. We'll just have to make that adjustment and.
In the electronic world, you always leave footprints behind.
Yes.
Yes.
I'll just summarize. So, Lordships, if your Lordships please takes Article 39, the Bear Act.
I'm sorry. My lord, my yesterday's note, my lord, if your lordship can just, it's volume 2B, short note on behalf of SGI.
On 31C, is it?
Just have a look at it.
The moment she finishes, then Zal starts, we'll ask him to read it out. So right.
Please, I'm sorry.
Yes.
Lordships, may I just read 39B once? Article 39B. May I read, your Lordship?
Yes, Parvana.
The state shall in particular direct its policy towards securing, B, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. So one emphasis is on the phrase of the community. Material resources of whom? Of the community. And the second phrase of importance or word is the word distributed. So the words community have to be read as being distinct from of the individual. Otherwise, the word community has no meaning. It's rendered absolutely redundant. And are so distributed. The emphasis of the entire provision is on distribution. Distributing what? The resources of the community. If your lordships now sees page 840 of volume 4A, the Black's Law Dictionary definition of distribution. Because distribution has always been given an interpretation as distinct from acquisition. Distribution is the giving away of something, as opposed to acquiring, vesting of something in someone. 840 of volume
At the
4A.
same time, Ms. Babar, we are interpreting a constitutional provision.
Yes.
And the well-settled principle is that constitutional provision is never interpreted like a statute, less like an income tax statute. You interpret a constitutional provision in a very broad sweep. And of the community, you are saying is distinct from the individual.
Yes.
Now, of the community is also capable of a broader constitutional understanding, something which bears upon the welfare of the community. Of the community. You don't have to go as far as Justice Krishna's, very, very Marxist or socialistic interpretation of that expression. You don't have to go as far as that. But of the community, even taking a very middle path can mean something in which the community is interested or which has a bearing on the welfare of the community.
So, Lordships, at the time the Constitution came into force, there was also Article 31, which recognized the right to property of an individual as a fundamental right. So 39B is part of the original Constitution. So when the origin of the Constitution is with 39B in Part 4 of the Constitution and Article 31, which is removed subsequently in the 44th Amendment. So Article 31, at the point of time, this was framed by our constitution makers. They were cognizant of the fact that Article 31 existed and recognized a fundamental right to property of the individual. So what I'm saying is, if you have to today read as what was the intention of and the problem is, your lordships, that there is really no material, there are no judgments except Justice Krishna Iyer's and those that follow Justice Krishna Iyer with respect to Article 39B. That's the handicap.
At the jurisprudential level, this case does require a lot of explanation by the court on what do we understand by the concept of resources for the purpose of the directive principles. As I said, you have two extreme views. The capitalist view, which regards all resources individualistic. You have the socialistic view, which regards all resources as of the community. And you have the Gandhian ideals, which are imbued in Part 4 of the Constitution, by which we hold our resources as a matter of trust for others. That there is a nuance which we'll have to, which has no case.
Which is the limited, yes, the limited points that I am making, your lordships, are one, the fact that there are different vesting provisions. 31A exists. So all the point that I'm making is just this, that the vesting does not happen in terms of 39B. That's the limited point. So it doesn't take away from the fact that if the state deems it fit.
Right. 39B is not a provision for either acquisition of a vesting.
Yes, that's the limited point.
Portatory, as they say.
That's the limited point.
It's only a goal.
Secondly, if it does not deal with acquisition, then surely there can't be a deemed acquisition under 39B. So 39B as a condition precedent would require an acquisition. That would be very dangerous because that would amount to an acquisition in terms of 39B, when 39B presupposes that there is already a pre-existing acquisition, and all that 39B does is it distributes so as best to subserve the common good. That is the obligation and the goal in terms of 39B.
So in order to distribute, acquisition may be necessary.
Yes, but that can't happen under 39B. So
That's the first step.
absolutely. Absolutely. The only limited point that I'm making is that the acquisition does not happen in terms of 39B. There is already, that's outside 39B. And secondly, how can you distribute something which is not owned? How can you distribute something which does not belong to you? So if your lordships want me to skip the definition, I'll just make the page reference is page 840 of volume 4A. I'll just hand over we have filed these, your lordships, and also emailed it, but there is some difficulty. We'll just place this.
A very substantial point, no doubt about it. I mean, absolutely. There's a very fundamental and profound point which you have made. You have to deal with it properly.
Yes, lordship. So if I may just hand over, there is a certain aspect.
Raising it, and you've raised it very, very coherently and very succinctly. You've raised it.
I'm so grateful. I just have one document which I want. It's already a part of the compilation, but this is a PDF version. It's easier to read. So I've put this together along with my written submissions. It's been e-filed, but there's certain aspects. There was an amendment proposed to the draft constitution.
Oh, you're on the Constituent Assembly debate?
Yes, you're right.
Because that's something we were yesterday saying, nobody has, by the way, Israel was saying yesterday, and Jamshid was also saying, nobody showed us a theory yesterday.
Huge throating of this one. Yeah.
Oh, one third?
One three. This is the start of the volume, Constituent Assembly Debates. And this particular debate is of 22nd of November, 1948.
Yeah.
So if your lordship sees page 21 of this, come to page 21. The middle of the page, where it says Mr. Vice President, after Naziruddin Ahmad, Mr. Vice President, then 885, Professor K.T. Shah. So this is the amendment number 885 proposed by Professor K.T. Shah. Professor K.T. Shah, Mr. Vice President, sir, I beg to move that for clause 2 of Article 31, the following be clause 2 of 31 is identical with 39B. We have put the clause of the draft constitution 31B also in the compilation, but your lordships may take it from me, it's identical with 39B.
It's quoted.
It's there.
It's quoted,
It is
quoted.
quoted there.
Noted just below.
Yes.
That is the substitution which you wanted. Substitution.
And secondly, this is referred to as Article 31, subclause 2, and that's the same as present 39, subclause B. The proposed amendment is what is now quoted, that for clause 2 of Article 31, the following be substituted. That the ownership, control, and management of the natural resources of the country in the shape of mines and mineral wealth, forests, rivers, and flowing waters, as well as in the shape of the seas along the coast of the country, shall be vested in and belong to the country collectively, and shall be exploited and developed on behalf of the community by the state as represented by the central or provincial governments or local governing authority or statutory corporation as may be provided for in each case by Act of Parliament. So one significant feature is that it specifies the kinds of natural resources. And the second significant feature is that it provides that these resources shall be vested in. Rather than using the word distribute, this proposed amendment brings in the phrase vested in and belong to the country collectively. May I just read that again, your lordships? At page, the third line of the amendment uses the phrase shall be vested in and belong to. And if your lordships comes to the third line from the bottom, I suggest therefore that it should be substituted by what I have just read.
Previous part also. Sir, the original clause.
Sir, the original clause for which I propose this one in substitution stands as follows. Subclause 2. That the ownership and control of the material resources of the community are so distributed as best to subserve the common good. I'm so grateful. That's verbatim identical to 39B. And then if your lordships comes to the third paragraph from the bottom, I suggest therefore that it should be substituted by what I have just read out, whereby the ownership, control and management of the natural resources shall be vested in the community collectively and shall be exploited, developed and worked by the community as represented by the central or provincial or local governments or by any statutory corporations that may have been created for the purpose. I think there can be no dispute on this proposition that as regards the natural resources that I have tried to describe, no human being has lent any value to those resources by his or her own labor. Your Lordships, we turn to the next page, page 22. Again, the third last paragraph. It is high time, therefore, page 22, third last paragraph. It is high time, therefore, that in this constitution we lay down very categorically that the ultimate ownership and direct management, conduct and development of these resources can only be in the hands of the state or the agents of the state, the representatives of the state, the creatures of the state like provinces, municipalities or statutory corporations. And thereafter, page 31, at the bottom of the page 31, Shri Jadubana Sahaya is the member who's addressing the Constituent Assembly. And on the next page, page 32, this is what he says about this clause. Fourth line from the top. I most respectfully submit that in this chapter, Article 31, that is the same as 39, is the pivot around which everything will revolve. Article 31, clause 2 is the most important feature for which I shall most respectfully draw the attention of the House, but it is not possible for me, I'm sorry, to support the amendment moved by my friend Professor Shah outright because I respectfully submit it is loosely worded. But I may state for the information of the House that so far as the principles which underlie his amendment are concerned, I support them. The spirit of it also I support. I fail to see why this august assembly, which meets only once in every country, is not keen to the extent of clearly and boldly incorporating in this article that the means of production and the natural or material resources of the country shall belong to the community and through it to the state. I can understand this. And the last line of that paragraph, I cannot understand how it is that the Congress, the predominantly majority party here, is not pressing this thing. And ultimately at page 33, bottom of the page, this is Dr. Ambedkar. Just that last paragraph on page 33, with regard to his other amendment, he's referring to Mr. K.T. Shah's amendment, namely substitution, page 33, last paragraph. Yes, that's important. With regard to his other amendments, namely substitution of his own clauses for subclauses 2 and 3 of Article 31, all I want to say is this, that I would have been quite prepared to consider the amendment of Professor Shah if he had shown that what he intended to do by the substitution of his own clauses was not possible to be done under the language as it stands. So if I may just pause here, Dr. Ambedkar is clearly referring to
This is what Professor K.T. Shah wanted to do by amendment is already there in this clause.
Yes, and he's clearly referring therefore to the, I'll just read the complete portion of what he says, was not possible to be done under the language as it stands. So far as I'm able to see, I think the language has been used in the draft in a more extensive language, which also includes the particular propositions which have been moved by Professor Shah, and I therefore do not see the necessity for substituting these limited particular clauses for the clauses which have been drafted in general language deliberately for a set purpose. I therefore oppose his second and third amendments. So the first line at page 34, for substituting these limited particular clauses, so here he's clearly referring to that part of the amendment which specifies the resources, which refers to mines and mineral wealth, forests, rivers and seas. That's the part which he does not really agree to, because he says that the original draft is more broad, and let's leave it at that.
What was thought was only with regard to natural resources.
Yes.
But so, they said it's more expansive.
Yes. The draft as such. This is the only discussion. There is no discussion really on the vesting, the clause on vesting, which was also proposed by him. There is no discussion, at least here, as far as I can see. So therefore, the fact of the matter is that there was an amendment which inter alia proposed an amendment which incorporated the word vesting and which was not adopted. Therefore, today the word distribution has to be given its meaning. There cannot be vesting under Article 39B. 39B would only come into the picture after the property has vested in the state, and the state is at the stage of distributing these assets. That is the only point of time where Article 39B can be invoked, and cannot be invoked in support of legislation that are vesting property in the state from private bodies, or where the property is being acquired. That's all, Your Lordship. I'm so grateful. Lordships, before I part, in the tradition of the senior Mr. Andhyarujana, I'd just like to thank Daisy Hannah, Oindrila Sen, and Rayana Mukherjee for all their contribution. Grateful.
May it please, please. Lord, I appear for. For individual house owners whose houses, my Lord, are subject to standard rent provisions, and for the yes, my Lord, there are my Lord the Chief Justice has very clearly, my Lord, placed the bar which your Lordships are going to consider. Lord, my first respectful submission is that if we look at Article 39B from the point of view of Article 31C, we are not going to get a distorted view. One reason, of course, is what my learned friend said, that at the beginning of the Constitution, 31C was not there. So, your Lordships, Lord, if your Lordships were to look, there is, of course, a link between 31C and 39B. But if that is going to be the starting point of inquiry,
39B cannot be interpreted from the lens of 31C.
And my Lord, this is relevant because all the nationalization cases that your Lordships have dealt with in the past, those are all very extreme cases where there's a complete taking of certain establishments, industries, etc. And then in that context, my Lord, a justification is given by the state and your Lordships will approve it. But at the dawn of the Constitution, all these provisions were not there. And like my learned friend pointed out, Article 31, Article 19(1)(f) were coexisting with Article 39B. So, my Lord, if that is the situation, and the second point, my Lord, would be that Article 39B has never been construed as a vesting of legislative power. There's a 5-judge bench decision of your Lordship saying very clearly that if at all we're talking about acquisition or requisition, etc., there are very clear entries in the Constitution that power is always there. So, in the context of acquisition and requisition, entry 42 of list 3 covers the area. In Ishwari Khetan's case, my Lord, your Lordship said that the state doesn't really have to bother too much subject to the definitions of industry, etc. The power is always there. And my Lord, even independent of that, the power of eminent domain is a concept which is so very well known in this Constitution that there is no doubt that if the government of the day wants to take over any property whatsoever, there is nothing really fettering them except Part 3, legislative competence, and not all the usual restrictions. So 39B would therefore not be seen as the source for the government or the parliament to do certain things. It is. There is no doubt about this throughout the interpretations of your Lordships. So if
directive principle, which is fundamental in the governance of the country.
I'm grateful.
It is a principle.
It is a principle. It is the purpose.
Not it's of power.
That's right. Which is why, my Lord, the Chief Justice said that if any of the laws, forget only 39B, my Lord, any directive principle of state policy, if it is sought to be given effect to, of course, it's a reasonable thing to do, provided always the nexus, etc., are clearly laid out. So, my Lord, we also cannot put it to so high that private property is off bounds at all points of time. That cannot be, my Lord. But for that, 39B interpretation is not going to be the starting point or even the ending point. 39B is a purpose. For achieving that purpose, there are other powers that the government always has had. Exercise those powers and then see, my lord, whether 39B is one of the objectives that is sought to be fulfilled. And why stop only with 39B? There are other directive principles also. So, my lord, in this context, how exactly are we supposed to look at a directive principle of state policy? What is the importance to be given to it? What is the primacy to be given to it? And what happens when a directive principle of state policy collides with a fundamental right? And not there is a wealth of jurisprudence of your lordships on this issue that something like a directive principle or a fundamental right part, they should never be so construed as to conflict with each other. They should be construed harmoniously. And I can do no better, my lord, than to place my proposition in Minerva Mills. My lord, the Chief Justice Chandrachud had very categorically placed the contours of the debate. And if we look at Article 39 from that perspective, then not much of the apprehension that the government would like us to believe that if there is an interference with 39B, we will lose a lot of ability to do certain things. Not all that will be washed away. So may I very quickly place paragraph 56 and 57 in Minerva Mills, volume 5, page 2050. At page 2079. Look, there are two paragraphs which I really need to place before your lordships. So just to provide context to my submission, that please do not look at 39B from the point of view of 31C. There is another much more primary, much more primal, much more important way to look at it. And that, my lord, is crystallized in this judgment. Para 56, may I place it? May I? No? Sorry, it's page 2079 in volume 5. May I please? My lord, just yes. Para 56. The significance of the perception that parts 3 and 4 together constitute the core of commitment to social revolution, and they together are the conscience of the Constitution, is to be traced to a deep understanding of the scheme of the Indian Constitution. Granville Austin's observation brings out the true position that parts 3 and 4 are like two wheels of a chariot, one no less important than the other. You snap one and the other will lose its efficacy. They are like a twin formula for achieving the social revolution, which is the ideal which the visionary founders of the Constitution set before themselves. In other words, the Indian Constitution is founded on the bedrock of the balance between parts 3 and 4. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. And then, my lord, the Chief Justice expounds on this. This is not mere semantics. The edifice of our Constitution is built upon the concepts crystallized in the preamble. We resolved to constitute ourselves into a socialist state which carried with it the obligation to secure to our people justice, social, economic, and political. We therefore put part 4 in our Constitution containing directive principles of state policy which specify the socialist goal to be achieved. We promise to our people a democratic polity which carries with it the obligation of securing to the people liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and the assurance that the dignity of the individual will at all costs be preserved. We therefore put part 3 in our Constitution conferring those rights on the people. Those rights are not an end in themselves, but are the means to an end. The end is specified in part 4. Therefore, the rights conferred by part 3 are subject to reasonable restrictions, and the Constitution provides that enforcement of some of them may, in stated uncommon circumstances, be suspended. And here is the pivotal part. But just as the rights conferred by part 3 would be without a radar and a compass if they were not geared to an ideal, In the same manner, the attainment of the ideal set out in part 4 would become a pretense of tyranny if the price to be paid for achieving that ideal is human freedoms. One of the faiths of our founding fathers was the purity of means. Indeed, under our law, even a dacoit who has committed a murder cannot be put to death in the exercise of right of self-defense after he has made good his escape. So great is the insistence of civilized laws on the purity of means. The goals set out in part 4 have, therefore, to be achieved without the abrogation of the means provided by part 3. It is in this sense that parts 3 and 4 together constitute the core of our constitution and combine to form its conscience. Anything that destroys the balance between the two parts will ipso facto destroy an essential element of the basic structure of our constitution. So, my lord, now, if we look at 31C, which is essentially a power in the arsenal of the state to acquire, to completely take away, then, my lord, Article 39B looks like a bulldozer. But Article 39B, your lordships have always felt, is a control on the power of the government. In the natural resources case, the presidential reference, your lordships has expressly said so, that 39B is a limitation on power. But if you look at it from 31C, then it looks like it is a very formidable power. But if the matter is looked at according to paragraph 56 and 57, and Lord, these observations have also been reaffirmed by the Rhine Judges Bench in Coelho's case. I'll place that paragraph before your lordship. So there is no doubt, Lord, that this balance between part 3 and part 4 is a part of the basic structure. If that is so, my lord, then Article 31C should not be definitive or determinative of the way in which 39B is to be construed. Firstly. Secondly, my lord, Article 31C, your lordships are very well aware, is a very peculiar article. It is in part 3 of the Constitution dealing with fundamental rights, but actually it is a Trojan horse. It takes away the fundamental rights. So how can that provision be part of a balancing equation between part 3 and part 4? It will lead to a distorted vision. Which is why, my lord, Mr. Sen's argument in Sanjeev Koko is very clear that when you look at 39B, distribution presupposes something to distribute. That something to distribute, there is no fetter on the power of the government. Why the apprehension is coming is because 31C provides an immunity against the challenge on Article 14 and 19, which the government of the day does not want to answer, of any day. And therefore, my lord, from this perspective, if we look at 39B, my lord, we will come to a wrong result. So with that, my lord, may I immediately take your lordships to what is the balancing that Article 39 in fact talks about. We'll keep the fundamental rights on one side, but 39B, my lord, in my respectful submission, is in continuation and part of, coupled with Article 38. One cannot be read without the other. And my lord, the use of the word in particular in Article 39, to some extent, my lord, helps my argument, but more importantly, the manner in which Justice Chandrachud has, Honorable the Chief Justice had interpreted it. 38 provides the bedrock, and 39 provides a further mechanism to give effect to it. My lord, please see Article 38 before we get into Article 39. Now, my lord, Article 37, lordships have seen that they are not enforceable, but my lord, we have come too far away. They are very important directive principles of state policy. My lord, we should not dilute the importance of that. Question is, to what extent does it justify a certain exercise of power? And if an immunity is sought to be claimed, my lord, whether your lordships will permit it or not. So Article 38, my lord, the language of Article 38, my lord, there were two amendments. The state shall strive to promote the welfare of the people by securing and protecting, as effectively as it may, a social order in which justice, social, economic, and political shall inform all institutions of national life. Then, Lord, subclause 2. The state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only among individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Lord, here I may just emphasize.
Came by the 44th Amendment.
That's right, Lord. Absolutely. Now, my lord, what is even the 44th Amendment focusing on? It is equality of status, facilities, and opportunity. It is not an equality of result. If I may explain this point. Every person, every citizen should have an equal opportunity to lead a better life. Provision of that opportunity is not the guarantee of an equality of result. Everybody who works hard is not going to succeed in life. Everybody who is who's got money may not get a certain commodity, whether he likes it or not. There is no equality of result which is guaranteed by Article 38. Now, my lord, this is very vital to understand Article 39.
There is one important
Yes,
difference, as Chief was pointing out yesterday. 38 is this big, 39 is smaller.
I'm obliged.
Difference is that 38 is not protected by 31 capital C.
That's right.
As they would like us to read capital 31.
That's right. But
That's the major difference.
yes, my lord, and that is exactly the canvas of this debate, that the parliament or the state legislatures want to provide.
39 only. But 39, 38 will not get that protection.
My lord, my respectful submission is that 39 is in species with 38. So
39 is illustrative of 38.
I'm obliged, my lord. So that becomes very clear immediately in Article 39. The state shall in particular direct its policy towards securing. Now, my lord, if there was no umbilical cord between these two, this word in particular, this phrase in particular is an unnecessary addition here, because my lord, it is perhaps a non-statable proposition that parliament or legislature can make a law which goes contrary to what is written in Article 39. There will be no law, my lord, which will be passed to.
Particular indicates that the state may follow certain other policy goals. But these have been emphasized by the Constitution.
I am obliged. And the larger policy goals are in 38. Now, my lord, this is where, my lord, this is Zulia's question.
Beyond 38. 38 also may not be. 38
My lord,
is broad. It says that social order in which justice, social, economic, and political shall inform all the institutions of the national life.
My lord, here the argument is that if equality of status, equality of facility, equality of opportunity is the goal, it is not equality of result, then you are empowering the dignity of people by saying that I will create the circumstances in which you can do your best, but beyond that, don't expect a result from the government. And that Article 39B, my lord, is exactly towards that the material resources of the community are so distributed so as to subserve the common good. So if your lordships were to interpret this in a manner that enhances the dignity of individuals, then, my lord, the meaning would be that acquisition or taking away a right. My lord, just as a footnote here, I am aggrieved by the rent control measures. There, my lord, it is not my property that is being taken away. There is a restriction put on my right to charge a rent. That restriction says that you can't charge more than the standard rent. Now, my lord, the Chief Justice had mentioned that a right to a property, like for instance, the pen or this book, this is my right. But, my lord, the Hoffeldian analysis says that my right to property is not just my right to this thing. Along with it, there are a number of other rights which are built into it. My right to preclude somebody else from it, my right to charge, the right to capital, my right to charge for this particular thing. These are all the various rights, and they're already protected to a significant extent by the Contract Act or the Transfer of Property Act. There is nothing very spectacularly unique about, my lord, my house rent stipulation. It is there in every lease, it is there in every contract. Now the question is, my lord, that when your lordships are interpreting a statute which is taking away a particular species of rights, how does that get construed in the context of acquisition, non-starter? How does it get construed in the context of taking away a right? There has to be, my lord, some connection between what is being taken away, to whom is it being given, and in what manner is it being given. And that is the answer to my lord's question, that Article 39B, in my respectful submission, actually only talks about how the government of the day can give effect to anything that it wants to do, any policy that it wants to do. So, my lord, throughout the 80s, 70s, 90s, your lordships have seen a spate of nationalization judgments. In the past decade or so, my lord, hardly any nationalization of a very big scale happens. Post 1995, your lordships have seen there's more and more private-public partnership. Now, the way in which the government should be able to do some things in a given socio-economic condition cannot be circumscribed by either the Constitution or by your lordships. The free play in the joint that the government may need in today's condition may not require nationalization, may require public-private partnership. Now, this creates a number of sub-issues. To whom are we going to give these resources? How are we going to give these resources? So Article 39B talks about how the ownership and control of material resources of the community, such as airwaves, such as gas allocations, such as private forests, such as mines and minerals. These are all, nobody can claim immunity from those being taken away on the basis of some fundamental right to property. But once they belong to the state, in whatever way, how they are going to be given is Article 39B. And if it should not result in crony capitalism is Article 39C. So the free play in the joint in Article 39B, which is how the parliament or the state wants to give effect to a particular policy by bringing in, for instance, auctions. Your lordships will deal with that issue. In the natural resources, the issue was clearly that, should we go for auction, or are there other ways in which the government can give away what are these material resources of the community? Your lordship said it's a case by case, very broad kind of a canvas on which the state has free play. You cannot prescribe only auction as the way, because that would be fettering it. Now, my lord, your lordships considered Article 39B in the natural resources reference. So Article 39B, my lord, is only this. It is only a leeway given to the government to do a thing in a particular way. Article 39C says that when you do that, it should not result in concentration of wealth, crony capitalism. That's all that Article 39B does. Anything more being read into Article 39B, my lord, is a burden which it doesn't need to carry. And my lord, the final respectful submission is only this, that please see the effect in this case. In the Malpe judgment, your lordships categorically held the predecessor act, 1947 act, to be violative of Article 14. There was no plea taken at that time that Article 31C is applicable. They could have been taken, they did not. Your lordships found that Article 14 is violated. The state made a concession that yes, we are actually going to redraw the law and we'll take into account this judgment, obviously, and also the model law which is being discussed with the housing ministers. What they did thereafter was they came out with the 99 law. Nothing but old wine in a new bottle, the same degree of toxicity which was found unfit to be consumed by your lordships. And then, Lord, please see the mischief here. When the matter came up, the state now says, we are taking protection of Article 31C. And that is recorded in the order, my lord, where there is another reference even in my writ petition. So, my lord, the point is, if 31A is going to be a shield against 14 and 19, even in cases like this, then, my lord, 39B is really in need of, my lord, insulation from the attacks of 31C. That's all.
Yes, Mr. Kunjan.
Lord, at the outset, my lord, on 31C, at the outset, there is no resistance in assisting your lordships. But we genuinely feel that that question is concluded, and we may perhaps
argue that, that is concluded and therefore it doesn't.
Lord, would your lordships, my lord, consider giving me 10 minutes? Why, my lord? Only on 31C. Lord, we have prepared a chart. Just for a quick reference, my lord, and this would be really handy, my lord. Yes, and your lordships may go by the color, because color has significance.
This red one survives.
No, every title has different color, and the change made is in that color.
Right.
My lord,
So-
permits if 31C, if it's being argued, then let us open as
No, I'm not arguing.
If-
I'm not arguing
Very
on merits.
good.
My lord, the first is, as introduced, my lord, 1971 amendment. Correct, my lord? Then post Keshwanand Bharti, my lord, what happened was, the blue part, my lord, Keshwanand Bharti title is in blue, therefore what happened is in blue, just for easy reference. And no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Rest is upheld by Keshwanand Bharti, 13 honorable judges. Then comes 1976 amendment.
So in Keshwan, they said that the immunity which is given, even challenging the nexus of the law to Article 39B, that immunity is struck down.
Yeah, correct. Correct. Rest is specifically upheld.
The 42nd Amendment.
My Lord, 76 amendment, my Lord. Yep, yes, your lordships are right. My Lord, that is in green, where instead of clause B and C of Article 39, the entire chapter 4,
All or any.
yes, my Lord, or any principles laid down in part 5, and blue, my Lord, continues from the previous. So your lordships are at this stage not concerned. Lord, kindly come to next. Then post 78 amendment.
Because 44th Amendment deleted Article 31 and 19(1)(a). So it was deleted from here also.
Therefore, my Lord, the article only read, my Lord, the title is read, and therefore Article 31 is deleted in here. Lord, now Minerva Mill strikes down, and what is struck down is, my Lord, also struck down in my chart.
But in your chart, the last column, you have again put the words "the principles specified in clause B or C of Article 39." That is the part to be decided. That is the part to be decided. Whether it is reversed.
No, I'm sorry.
You inserted it.
In your last column, 1 through 3, 4th, 5th column.
Yes, my Lord.
What Minerva Mill struck down.
That's our case, and that is accepted by 5 judges.
Second, all or any of the principles laid down in part 4, that is struck down in Minerva Mills.
Correct, my Lord.
And therefore you have deleted it in your last column.
Correct, my Lord.
But does that have the effect of restoring the words, the principles specified in clause B or
Whether the revival issue.
That's
Revival.
right.
Yes, my Lord. That's, my Lord, the content. So, my Lord, according to us, this is how
This is how it is to be read now, that's right.
31C, and that is how your lordships have.
Why you have inserted it?
No, not we can't insert. Here, yes.
Last column.
Yes.
In the
Yes.
chart.
Your lordships are right.
But whether it is as a matter of law, constitutional law, whether this is the...
Your lordships have said so in a combination of 5 judges.
All right, now let's see that.
That's what, my Lord, I'm saying. My Lord, first, kindly see, my Lord, my note, my Lord, which I used yesterday, volume 2B, my Lord. Volume 2B, my Lords. Lord, I skipped it yesterday, my Lord. I'll just, Lord, highlight at the cost of repetition, saying that there is no resistance. But I'm just saving time, my Lord. It's concluded by a 5-judge bench and not disputed or doubted anywhere subsequently. Lord, after I'll just read para 15.
Volume 2B page?
6, my Lord. 6. PDF 6, my Lord. The title is Issue Concerning Revival.
Yes.
Lord, your lordships may kindly bear in mind, my lord, the question which was framed in 31, with regard to 31C, was a judgment of 3 honorable judges in 1980. Now, my lord, 1986, my lord, I stand corrected. Now we are in Vaman Rao, my lord. It is at the outset, it is submitted that the validity of the unamended provision in 31C prior to the 42nd amendment is no longer res integra. It is submitted that Article 31C was specifically upheld by the judgment of 13 judges in Keshwan and Bharti. The effect of judgment in Minerva Mills on the validity of unamended 31C post Keshwan and Bharti was specifically raised and rejected as far back as in judgment in Vaman Rao Supra. In Vaman Rao, a bench of 5 judges held as under. That leaves for consideration the challenge to the constitutional validity of unamended Article 31C. As we have stated at the beginning of this judgment, Article 31C was introduced by 25th Amendment. Initially, it sought to give protection to those laws only which gave effect to the policy of the state towards securing principles specified in Clause B and C of Article 39 of the Constitution. No such law could be deemed to be void on ground that it is inconsistent with or takes away or abridges the right conferred by Article 14, 19, and 31. The concluding portion of the unamended article, which gave conclusiveness to certain declarations, was struck down in Keshwanand Bharti in so and so. Sri M.N. Phadke, who led the arguments on behalf of the petitioners, built a formidable attack against the virus of Article 31C. But with respect to the learned counsel, the effort is fruitless because the question as regards the validity of 31C is no longer res integra. The opening clause of Article 31C was upheld in majority in Keshwanand Bharti, and we do not quite see how the petitioners can be permitted to go behind that decision. Then, my lord, again a highlighted part. The question of validity of 25th Amendment, by which the unamended Article 31C was introduced into the Constitution, was specifically raised before the court, and the arguments in that behalf were specifically considered by all the 6 minority judges and Justice Khanna. It seems to us difficult in these circumstances to hold that no common ratio can be culled. But that was the argument, that because of various different judgments, common ratio is not possible. The court rejects that. It seems to us difficult in these circumstances to hold that no common ratio can be culled out from the decision of the majority of 7 judges who upheld the validity of Article 31C. Putting it simply, and there is no reason why simple matters should be made complicated, the ratio of majority judgment in Keshwanand Bharti is that first part of Article 31C is valid. Apart from this, if we are right in upholding the validity of Article 31A on its own merits, it must follow logically that unamended Article 31C is also valid. Unamended portion of 31C is not like an uncharted sea. It gives protection to a defined and limited category of laws which are passed for giving effect to the policy of the state towards securing the principles specified in Clause B or Clause C of Article 39. These clauses of Article 39 contain directive principles which are vital to the well-being of the country and the welfare of its people. Whatever we have said in respect of the defined category of laws envisaged by Article 31A must hold good, perhaps with greater force, in respect of laws passed for the purpose of giving effect to Clause B and C of Article 39. It is impossible to conceive that any law passed for such a purpose can at all violate Article 14 and 19. Article 31 is now out of harm's way. In fact, far from damaging the basic structure of the Constitution, laws passed truly and bona fide for giving effect to directive principles contained in Clause B and C of Article 39 will fortify that structure. We do hope that Parliament will utilize to the maximum its potential to pass laws genuinely and truly related to principles contained in Clause B and C of Article 39. The challenge made to the validity of first part of the unamended Article 31C therefore fails. My Lord, and my Lord, order of the court at page 8.
But therefore, they say that Article 31C as originally enacted was upheld by the judgment in Keshwanand Bharati, except for that last part, the last portion. But they don't say that that original amendment, that the original position is revived after they struck down the amendment brought about by the 42nd Amendment. That declaration is not issued.
My Lord, that is subsequently in a judgment. Therefore, my Lord, I'm saying with a sense of responsibility, not to avoid, my Lord, addressing on that. My Lord, and my Lord, this judgment is after Minerva Mill judgment, after taking note of Minerva Mill judgment. My Lord, please see.
Common Rao is after.
After, my Lord, yes, my Lord. It takes note of Minerva Mill and says that what will be the effect of Minerva Mill judgment in 31C.
Actually was the operative order was pronounced on the same day.
Same
9th
day.
of
Lord,
May.
please see that order of
But
the,
Vaman Rao, the actual reasons were delivered in November. I think Minerva came in August. If I'm not
Yes.
mistaken. July.
Right, but it was specifically stated that this will go to May 8.
Yeah.
We read as May 8.
There is one
Both
thing,
of the same day.
Same date.
Lord, would your lordships come to page,
These are the bill-
I'm sorry.
one thing, this chart shows had made this provision by 76 amendment quite wider.
Yes,
Your amendment was the principle and all that, including this part 4. Part 4.
entire passport, not just 39,
Part,
B and C.
these lines were struck down by the court.
Yes,
So how you can import the limited part when the wider is struck down?
no, limited was sustained, wider was struck down.
Wider was the wider goes.
But the brother is saying, how will it come back on its own?
That's why,
You would like us.
Lord, it was sustained in Keshwanand Bharati, my lord, that's what Vaman Rao said.
Sustained in Keshanan, then section 4 of the 42nd amendment substituted it completely.
My lord, can your lordships,
Substituted section 4 was
Lord.
struck down in Minerva.
my lord, if your lordship wish to go into it, we will go into it. My lord, right? But kindly, my lord, allow me, there is a last 5 judgment
Now,
which
tell us-
squarely deals with this.
Show us if from Minerva, what is the operative order? What is struck down in Minerva? Let's just see Minerva.
Lord, can I show, my lord, this complete, this,
Before that, just let's see what is struck down in Minerva.
Yes.
let it be taken up. My lord. My lord, I think, my lord,
No, we want Minerva. What is the operative part in Minerva? That's all. Just show us that. It will just complete this process for us. That's all.
my lord,
And
if
if
your lordship
my-
see, my lord, that is there in page 7. That's what I'm saying.
Why don't you show us from
Well,
volume 5?
I'll show it, my lord, from there.
Volume 5.
In the meanwhile, if I may
Yes.
just point out one fact with my lord,
Point out-
Justice Bindus, no, not my argument.
Solicitors on his
Lodge,
right.
lodge.
Just tell us what is the page of the operative direction in Minerva?
2085.
Paragraph
2085.
Which volume is it?
Volume 5.
Volume 5, page 2085.
Yes. Para 70, my lord. 75, my lord, 75. Yes. Those then are our reasons for order, which we passed on 9th May, as my lord, the Chief Justice was, to the following effect. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic essential feature of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abrases any of the rights conferred by Article 14 or 19 of the Constitution if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4. So the entire directive principles of state policy.
Of the 42nd
My
Amendment.
lord, would your lordships,
1-4. Where did we get that page?
It's 2066.
2066.
Para 14.
May I assist your lordship and the learned solicitor general? Lord, the correct observation is para 58.
If you don't mind, Zal, I'll just conclude.
Question never was he specifies that.
2066. Correct.
Lord, I left my note, my lord, at a very crucial juncture, my lord. If your lordship
We come back.
would have seen the operative part of Vaman Rao, my lord, would have assisted, your
We'll
lordship.
just look at this and then go to that.
Yes, my lord. Para 14. Section 4 of 42nd Amendment, which was brought into force with effect from January 3, 1977, amended Article 31C of the Constitution by substituting the words and phrases all or any of the principles laid down in Part 4.
That's
for-
a little bit of a ticklish issue because it substitutes all or any of the principles.
Well, that is considered, that issue is, well, that issue is considered by a 5-judge bench.
All right. Now
That's
we'll
not
go
what
back-
I want your lordships
We'll
to
go
see.
back to your note, yes.
Yes, Lord. Lord, page 7, page 8. Lord, PDF page 8, Vaman Rao. Roman 2B, short note on behalf of SG, my lord, and it's page 8. Lord, this is the order of the court. My lord, this is quoted by me.
Two is when you're opening a new.
We'll have to. I feel, my lord, your lordships.
I think the logistics about opening multiple windows, that's all. Nothing else.
No. My lord, order of the court, page 8, my lords.
Page?
Page 8, PDF 8, note, my lord, volume 2B.
Page 8, para?
The order of the court.
Oh, order of the court. Yes, yes.
This is not my words, my lord, that's how it is recorded in the judgment. Article 31C of the Constitution, this 5-judge bench in Vaman Rao. Article 31C of the Constitution, as it stood prior to its amendment by Section 4, there is a declaration, yes. And thereafter NGSC. After considering Minerva, Vaman Rao, my lord, the judgment says this. The Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of Constitution 42nd Amendment Act, is valid to the extent to which its constitutionality was upheld in Keshwanand Bharti. The revival declaration. Lord, as my learned friend Mr. Shankar Narayan rightly says, that if a player is on the field, you send a substitute goes, the player also doesn't go, but simultaneously. He remains. As it stood prior to so-and-so, Article 31C, as it stood prior to Constitution 42nd Amendment Act, does not damage any of the basic,
Now tell us, Mr. Solicitor, when a constitutional provision is amended by substituting a new provision in its place, does the original provision stand?
yes, madam. That is what was again considered.
This is their entire argument, that it doesn't.
When a constitutional provision is substituted by a fresh provision, the fresh provision comes into force instead and in place of the original provision. Right? Now, if the validity of the fresh or the amended provision is struck down, on what theory of law does the original provision get revived? That's the point.
Would your lordship see, my lord, the NJSC judgment, again a 5-judge bench, where this question is squarely raised?
Now, since you are on Vaman Rao, remember Mr. Nariman had argued that, well, Vaman Rao proceeded on a concession by Mr. Palkiwala. Where is that concession recorded in Vaman Rao?
Not in Vaman Rao, my lord, that's in Minerva.
The assumption.
Assumption is where? In Minerva and Vaman Rao?
That's Mr. Nariman's argument.
Mr.
In Minerva.
That's his argument. That's not what is held. But Mr. Nariman's argument is based on which part of the judgment? He said that Mr. Palkiwala conceded this position. Now, where does Mr. Nariman get that from?
There's no concession.
Probably that is in.
That is in Sanjeev Coke's problem.
That is probably in that case. When Minerva Mill is being discussed by Justice O. Chinnappa Reddy, and then there is something.
Now, NJSC, where do we get? Yeah, that's right.
Yes, my lord, kindly have come to NJSC. NJSC squarely the my lord, question which fell from my lord, the Chief Justice, my lord, was raised.
Check up somebody.
In the meanwhile, no, we'll do that.
Where is it?
Volume?
Yeah, it may be in.
Volume? NJSC.
We are perplexed, something like that.
Huh?
We are perplexed.
Yeah, your lordship.
The judge says that. We are not saying it.
In Sanjeev Coke, they have said that bench was perplexed.
Perplexed by this.
Judgment in Minerva Mills,
Yes.
And then it comes.
not us.
Yeah, your lordship will never be perplexed. A page number? Lord, please come to volume 5, NJSC judgment. This contention was raised.
Which page?
Lord, page 3877, my lord. Para 408. There is a title given in the judgment.
Mr. Solicitor, that argument of Mr. Nariman's, which is referred to in the first referring order, was on the basis of Minerva. Because I'm now at volume 5, page 2790.
Correct.
Where he says they record Mr. Nariman's submission, volume 5, page 2790. He contended that the decision in Minerva Mills proceeded on the basis of a concession made by Mr. Palkiwala and on an assumption that Article 31C, as it survived as a result in Keshwan and Bharti, stood revived after the subsequent events. That seems to have been his submission at that point.
Yes, my lord, your lordships are on page 2790, my lord.
790.
Para 5.
Para 5, Mr. Nariman's submission.
My lord, I would, my lord, speaking for myself, my lord, when Nani Palkiwala gives some concession, my lord, on the basis of Keshwan and Bharti, my lord, I would respectfully buy it, my lord. There must be a good reason not to. Yes, my friend, my lord. Para, my lord. No, para. What's the 2069. 2069, my lord. But possibly it's not concession. Para 24, my lord.
No, it's 5.
This is Minerva.
This is Minerva Mills. Possibly the paraphrasing by Mr. Nariman, my lord, appears to be a little inaccurate. It was not a concession.
Which was the para in Minerva page?
my lord, page number 2069, para 24. Does my lords get, my lord?
Yes.
The next question which we have to consider is whether the amendment made by section 4 of the 42nd amendment to Article 31C of the Constitution is valid. Mr. Palkhiwala did not challenge the validity of the unamended Article 31C, and indeed that could not be done. The unamended 31C forms the subject matter of a separate proceedings, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshwanand Bharti. It was neither on assumption or concession. But possibly, Mr. Sirvai in his book writes, but possibly, Mr. Sirvai in his book writes that this was a concession. Possibly, well, that's from where, my lord, Mr. Nariman, my lord, the learned counsel, Mr. Nariman. Yes, it's a statement of fact, my lord, not a concession.
Yes.
Now, my lord, may I come to my lord NJSC judgment?
NJSC, now where is NJSC?
3877, at 3877. Same volume, my lord. This is, my lord, majority view of my lord Justice Kehar. And on, my lord, similar view is taken by Justice Joseph also. Which is the para number? Let's see. $255, similar submission is raised, my lord. I'll just, my lord, come to that. But please see 5, the effect of striking down the impugned constitutional amendment. Does your lordships get, my lord? Would the amended provisions of the Constitution revive if the impugned constitutional amendment was to be set aside as being violative of the basic structure of the Constitution? It would be relevant to mention that the instant issue was not adverted to by the learned counsel for the petitioners, possibly on the assumption that if on consideration of present controversy, this court would strike down the Constitution 99th Amendment Act, then Article 124 so and so, as they existed prior to the impugned order, would revive. And on such revival, the judgment rendered in the second and third judges' case would again regulate selection and appointments, as also transfer of judges of the higher judiciary. A serious objection to the aforesaid assumption was raised on behalf of the respondents by the learned solicitor, by the Solicitor General, who contended that striking down of the impugned constitutional amendment would not result in the revival of provisions which had been amended by Parliament. My lord, contrary to what I am urging now was the argument that it doesn't revive. In order to canvass the aforesaid proposition, reliance was placed on Article 367, which postulates that provisions of the General Clauses Act had to be applied for an interpretation of the articles of the Constitution in the same manner as the provisions of the General Clauses Act are applicable for an interpretation of ordinary legislation. Insofar as the instant submission is concerned, we have no hesitation in affirming that unless the context requires otherwise, the provisions of the General Clauses Act would apply. Now kindly directly see 3886. Lord, I'm sorry, my lord, my learned wants me to come to 3813 first.
38?
Based on, my lord, what? 3813, my lord. Para 255.1. These very proceedings were relied upon by, my lord, my worthy predecessor, the learned Solicitor General. Your lordship gets, my lord? This is the same judgment, NJSC. The contention is noted, my lord.
Property owners.
Yes, my lord. Firstly, that the issue whether a constitutional amendment once struck down would revive the original substituted article was a matter which at 255.1, my lords. Page 3813. So please see the last sentence, my lord, of this. After quoting, my lord, the judgments, Property Owners Association, my lord, all three Property Owners Association, respective references. It was submitted that the order passed by this court, my lord, am I with your lordship, my lord? Order passed by this court wherein the reference to a 9-judge constitution bench had been made was a case relating to constitutionality of Article 31C. It was pointed out that Article 31C, as originally enacted, provided that it was submitted that the later part of 31C, which provided, and no law containing declaration that it is for giving effect to such policy, shall be called in question in any court on the ground that it does not give effect to such policy, has been struck down by this court in Keshwanand Bharti case. It was contended that when the matter pertaining to the effect of the striking down of a constitutional amendment had been referred to a 9-judge bench, it would be improper for this court, sitting in its present composition, to determine the aforesaid issue. So, my lord, the request was that on this issue, you kindly refer it to a larger 9-judge bench. And, my lord, now the answer, my lord, at page.
And then 255.2.
Yes, I'm sorry, my lord.
This is a submission of the Solicitor General then.
Yes, my lord. The second contention advanced at the hands of the learned Solicitor General was based on section 6, 7 and 8 of the General Clauses Act. It was contended that an amendment which had deleted some part of the erstwhile Article 124 of the Constitution and substituted in its place something different, as in case of Article 124 of the Constitution Act, 99th Amendment Act, would not result in the revival of the original article which was in place prior to the constitutional amendment. Even if the 99th Amendment itself was to be struck down, it was submitted that if a substituted provision was declared as unconstitutional for whatever ground or reasons, the same would not automatically result in the revival of the repealed provision. In order to support the aforesaid contention, reliance was placed on so-and-so, 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 my lord. It was submitted the general rule of construction.
Now, you go by this.
Lord, now please come to, my lord, page 3877. I'm just, my lord, trying to point out, my lord, that there was a suggestion that in a combination of 5 honorable judges, revival question be not decided, because this reference, this particular present reference is referred to a 9-judge bench, and it does not stand revived. That was the contention. My lord, I have read para 408, 409 under the title Effect of Striking Down of the Impugned Constitutional Amendment. Now, please, my lord, directly come to page 3886.
Page
3886. My lord, all the judgments, my lord, which the learned Solicitor General, my lord, the then Solicitor General, my lord, referred to and relied upon were discussed. And my lord, after the quotation of the judgment, after classitum D, what needs to be noticed, does your lordship state, my lord?
Yes.
What needs to be noticed
Page 3886, 3886.
Malad, may I read? Your ladyship gets, Malad.
886.
3886, after the quotation of the judgment relied upon, just below classitum D. What needs to be noticed from the extract reproduced above is that this court, in the above judgment, clearly concluded that the legal effect on an earlier law, when the later law enacted in its place was declared invalid. But may I continue, Malad, and after that?
Yes, their argument. Not argument. were reading NJSC.
Yes, my lord, I must say, my lord, sometimes we assist your lordships as officers of the court. And your lordships would find out why. My lord, the way, my lord, if we travel the path, my lord, which we are considering, your lordships are considering, what would be the consequence? Now, please bear in mind, Article 124 was in question in this judgment, which says that the president, in consultation with such judges as he thinks appropriate, will make appointment. There was a substitution by the word National Judicial Commission. And the argument made was on our behalf, the Solicitor General, that now that provision goes because you are declaring the provision to be unconstitutional. Please see 3886. What needs to be noticed from the extract reproduced above is that this court in the above judgment clearly concluded that the legal effect of an earlier law, when the later law enacted in its place was declared invalid, did not depend merely upon the use of the words like substitution or supersession, and further, that it would depend on the totality of the circumstances and context in which the provision was couched. If the contention advanced by the learned Solicitor General is accepted, it would lead to a constitutional breakdown. The tremors of such situation are already being felt. The retiring judges of the higher judiciary are not being substituted by fresh appointments. The above judgment, in our considered view, does not support the submission being canvassed because on the consideration of, then, my lord, the earlier judgments quotes are taken, totality of circumstances and the context. The instant contention is just not acceptable. We are therefore of the considered view that even the instant judgment cannot be of no avail to the respondent insofar as present controversy is concerned. Now, please come to 3888. This is, my lord, the majority view penned by my lord Justice Kehar, my lord. But immediately after the quotation, what needs to be kept, my lord, your lordship says that. What needs to be kept in mind, as we have repeatedly expressed above, is that the issue canvassed in the judgments relied upon was the effect of a voluntary decision of a legislature in amending or repealing an existing provision. That position would arise if Parliament had validly amended or repealed an existing constitutional provision. Herein, the impugned constitutional amendment has definitely the effect of substituting some of the existing provisions of the Constitution and also adding to it some new provisions. Naturally, substitution connotes that the earlier provision ceases to exist and the amended provisions takes its place. The present situation is one where the impugned constitutional amendment by a process of judicial review has been set aside. Such being the position, whatever be the cause and effect of the impugned constitutional amendment, the same will be deemed to be set aside and the position preceding the amendment will be restored. It does not matter what are the stages or steps of the cause and effect of the amendment. All the stages and steps will stand negated in the same fashion as they were introduced by the amendment when the amended provisions are set aside.
But
Then please.
against what you are canvassing, because that was there, they say if it's a pure substitution, the earlier provision ceases to have effect. They said since the substituted provision was held to be unconstitutional by the Supreme Court, therefore the earlier provision is revived. But when there is a pure substitution, as in the case of 31C being substituted, the earlier provision ceases to have effect.
That is negative by them. May I read?
No.
May I read, my lord?
Yes. What needs to be kept in mind?
Kindly a little above that, my lord.
B, placitum B.
B. What needs to be kept in mind, Lord, I have no difficulty, your lordships may go into. I am just, Lord, sounding an alarm. What will be the position, my lord? What will be the consequence of holding?
Consequence, we will see what is to be done if we are of the view that, well, the original 31C is not revived. What consequence we will of course have to
I'm not on 31C. 31C is also few words substituted. Few words are substituted in 31C. Here also, instead of consultation with as many judges, such judges.
They say that this was not a case of a pure substitution. but that a substituted provision was held to be unconstitutional by the Supreme Court. And therefore, they say it is unconstitutional on the date of its enactment, and therefore the original provision continues to
That is
subsist.
the proposition in 31C as well.
No.
Then I have nothing to say. Lord.
How?
What is the position, my lords? That is the position. Minerva Mill strikes down that substituted part.
Section 4, the entirety of Section 4 of the 42nd Amendment completely substitutes that provision.
Does read Section 4, Section 4.
Lord, same NJSE. Well, I'll just point out, same is NJSE, my lord. My lord, I have no difficulty if your lordship takes the view that the government would stand to benefit. I'm assisting your lordship as an officer of the court. In a, my lord, we can go into academic discussion. I'm just pointing out the catastrophic, my lord, the void which is created. What will be the impact of that void? That's what I'm saying. My lord, suppose, give me allow.
There is no void, as in the case of NJSC. NJSC, what happened was, they said that there's a breakdown of constitutional machinery because there would be no mechanism left. This is only an immunity provision.
Lord, if that is the distinction your lordship draws, my lord, then, my lord, we are on whether.
The law does not become ipso facto invalid. It only loses its immunity from challenge under 14.
Lord, suppose, my lord, kindly, my lord, sounding an alert as an officer of the court. The parliament does not like a particular provision. It substitutes a part of it. Kindly, my lord, allow me, my lord, your lordship's attention for some time. There would be some more distinctions your lordship will be able to draw, my lord, from this, my lord. But allow me, my lord, a more little, my lord. I'm sorry.
Yeah.
Parliament does not like the particular provision. It substitutes the way Section 4 was. Your lordships have seen, and I'll show NJSC my lord, the provision also. I have kept it ready. It substitutes a part of it, which is declared unconstitutional, and as the other side is contending, the entire provision does not revive. It goes. Correct, my lord? The parliament may not reenact the original provision. And the court can never issue a mandamus to the parliament to.
But that's the discretion of parliament. That ultimately.
Lord, please do that, my lord. I am happy with that, my lord. I am happy, my lord. Even in this case, I'll show it's exactly identical. Section 4 of 31C was, my lord, NJSC. I'll show. That was precisely the argument.
Possibly, because what you are contending is that the substituted words by the 42nd Amendment was struck down by this court.
Right, my lord. Therefore, therefore a declaration. In Vaman Rao, there was a declaration made that the position as prevailing prior to that amendment will now stand restored and revived. And no court has thereafter doubted that. I'm saying something against me, my lord. I'm not resisting that. As an officer of the court, my lord, I'm before a 9-judge bench. Lord, possibly, therefore, after Vaman Rao, no 5-judge bench has, my lord, gone into 31C revival issue. Possibly, my lord. This is my assumption. Now, please see, my lord, further. Para 413. Even though we have already recorded our determination with reference to the judgment cited by the learned Solicitor General, it is imperative for us to record that it is evident from the conclusions returned in central provinces so-and-so, that in facts and circumstances of the present case, it would have to be kept in mind that if the construction suggested by the learned Solicitor General was to be adopted, it would result in the creation of a void. We say so because if neither the impugned constitutional provision nor the amended provision of the Constitution would survive, it would lead to breakdown of the constitutional machinery inasmuch as there would be a lacuna or a hiatus insofar as the manner of selection and appointment of judges to the higher judiciary is concerned. Such a position, in our view, cannot be the result of any sound process of interpretation. Likewise, from the observation emerging out of the decision rendered in Indian Express we are satisfied that the clear intent of Parliament while enacting the Constitution 99th Amendment Act was to provide for a new process of selection and appointment of judges to the higher judiciary by amending the existing provisions. Naturally, therefore, when the amended provision postulating a different procedure is set aside, the original process of selection and appointment under the unamended provision would revive. The above position also emerges from the legal position declared in Koteshwar Vittal Kamat. It is not possible for us to accept the inferential contention advanced at the hands of the learned counsel for the respondents by placing reliance on section so-and-so of General Clauses Act. We say so because the contention of the learned Solicitor General was based on the assumption that a judicial verdict setting aside an amendment has the same effect as a repeal of an enactment through a legislation. This is an unacceptable assumption. When a legislature amends or repeals an existing provision, its action is its own free will and is premised on well-founded principles of interpretation, including the provisions of the General Clauses Act. Not so when an amendment repeal is set aside through a judicial process. It is not necessary to repeat the consideration recorded in para so-and-so above. When a judgment set aside an amendment or repeal by the legislature, it is but natural that status quo ante would stand restored. But possibly your lordships may not like to draw the distinction between a provision which creates a void and a provision which does not create the void. Your lordship would decide the question of law, what would happen when there is declaration of unconstitutionality of a part of the provision. Whether it is 31C, which possibly may not leave any void, and will leave a void, I'm on demurrer, that it may not leave a void, and here it would leave a void. Now please see, my lord, the other view, my lord, at page 4106. 41. I'm sorry, my lord, my friends, my lord, want me to. 415, my lord. 415, my lord. For the reasons recorded herein above, my lord, the same. The same page, my lord, page 3889. Same page which I was reading. For the reasons recorded herein above. Submission is when an amendment which substitutes few parts of a main provision is struck down. Without that part, the provision remains. That is, my lord, the position. And if your lordships, I'll show to.
Question is, what part remains?
Unamended part, my lord, which is not set aside.
The unamended part minus the substituted part may possibly remain. But in
Yes,
this case,
that's all we are saying.
but in this case, minus the substituted part, the original part has no meaning at all.
No, my lord, it has a meaning. Please take the chart, my lord.
Yes.
Please take the chart, my lord. Please take the chart, my lord. My lord, kindly see the.
Second last column. Take the second last column.
I'm taking that, my lord. Achha,
Or take the third last column actually. Post
It could revert back, my lord, to what the Keshwanand Bharati, my lord.
No, it doesn't. That's the point. Just see, I'll tell you why.
My lord, it's better, my lord, we will address your lordship on marriage. I was arguing against me. That please don't go into this, don't travel into this path. Because there are several judgments which have come relying upon, my lord, 131, 134.
It's not that clear. It's a very debatable issue. We have to decide the issue.
It's not therefore referred to your lordship.
See the third last column. Okay, the third last column, 31C.
Yes, my lord.
Saving of laws giving effect to certain directive principles. Notwithstanding anything contained in 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by 14, 19 or 31. Right? After that it was struck down in Keshwanand. Now, if this part, all or any of the principles laid down in Part 4 is obliterated because it is struck down, then how does...
This is not struck down, my lord.
Of course, this is struck down in Minerva Mills.
No, my lord. Look, kindly see, but just third...
Principles laid down in Part 4 is struck down in Minerva
My
Mills.
lord, third column, please see third column. My lord. Section 4 of, my lord, post 76. The principles specified in clause B or clause C
Confusion because of the...
the confusion which we have.
Para 58 of Minerva. Para 58 of Minerva Mills says, Para 58 of Minerva Mills, which is at page 2079 says, that by granting immunity on a challenge based on Article 14 and 19, on the ground that the directive principles are being subserved, they say every legislation virtually will be protected by that umbrella. So they strike it down on the ground of basic structure, saying that giving an immunity from 14 and 19 would violate the basic structure. That's the problem.
merits. Allow me to clarify
Yes.
the confusion which this chart.
Functional utility of 14 and 19 goes. Then
Take the chart for a second.
Yes.
Take the chart. And it comes in the third chart.
The third column.
The third column, whichever being. This is my.
Right.
The principles specified for clause C or weight of
All right. Now just let's wait here for a second. The words, the principles specified in clause B or clause C of Article 39 is subsumed in the expression all or any of the principles laid down in part 4.
substituted.
Subsumed. It is subsumed.
The word used is anyway, subsumed.
Substituted is a legislative device, but subsumed means the larger includes the smaller. So if the earlier words are subsumed in what is substituted, then when the entirety of what is substituted is struck down, that will not result in the revival of what is the original provision. That's the problem.
Only a minute.
And if you read this now in the context of para 58 of Minerva, they say that granting this immunity on the grounds of 14 and 19 itself violates the basic features of the Constitution. That's the problem.
Lord, kindly, Lord, I wanted to,
See, NJSC, I'll tell you one thing. NJSC, they realize that there is a problem. Namely, that when you strike down, that's why the Solicitor General was arguing, your counterpart was arguing that, look, if you strike down the NJSC amendment, that will not result in revival. That's why what did the court throw in the exercise of its 142 power? They said, one second.
not 142, the court interprets. What interprets?
What did the court say? The court said that this will lead to a constitutional breakdown. We are not in a situation of constitutional breakdown. Why? Because if 31C is no longer there, all that it means that any law has to meet the standard of 14 and 19. No law is invalidated ipso facto.
That would be a.
Not be tested, that's all.
Lord,
there is no constitutional breakdown.
That would be distinction without a difference, my lord, only
The
to.
law is lifted.
I'm sure your lordships would not try to come out of NJSC finding on 142. It was a finding. It may be wrong finding.
All right, no, forget 142. But NJSC, in 2 paragraphs, they say that this will result in a constitutional breakdown. Justice Keir says that they will. We were trying to see whether there will be a constitutional breakdown in a case like this. There wouldn't be, because no law then becomes invalid. It's just that the law has to be justified by the state. Being a reasonable legislator.
I wanted to read few more paragraphs, but if your lordships have, my lord, decided to not go into it, I wanted not, my lord, your lordships to persuade not to, for good reasons. But if your lordships, my lord, have decided, I have nothing more, lordship.
We have to look at it because NJSC doesn't, the logic of NJSC.
It's not referred, my lord. Therefore, my lord, I think advisedly not referred. Should we, my lord, expand the scope? Lord, would your lordships read para 70?
Do is this.
Only a minute, only a minute.
Do is this. We have heard you now on this. We have told Mr. Andhyarujana, he has to argue the 31C point. Let's hear Mr. Andhyarujana.
That means our point is rejected, my lord. But before your lordship rejects our submission, 2085.
Not rejecting it. Hear Mr. Andhyarujana, we've heard you on that.
That amounts, and doesn't matter, it's entirely your lordship's jurisdiction.
Yesterday we prevented him from arguing it. Let us hear what he has to say, then we'll take a call.
2085, my lord, would your lordships come?
At the end of it, we may still say that 31C, we need not go into it at all. We may still say it and say that, well, Vaman Rao says this, Minerva Mill says this, NJSC says this. Or if he persuades us to a contrary viewpoint, we may take a contrary view, but we'll have to hear him for that. Because yesterday
only a minute, my lord, before that, would your lordships come to para 75 of Minerva Mills?
Yes.
It's 2085. And keep, my lord, section 4 in mind. Your lordships have read section 4.
Since we are on 75, why don't we reach 58 and then go to 75?
58.
It's the challenge. Let's go to para 58.
Yes, ma'am. It's 2079. It is in this light that the validity of the amended Article 31C has been examined. Article 13(2) says that states shall not make any law which takes away or abridges the rights conferred by Part 3, and any law made in contravention of that clause shall be, to the extent of contravention, be void. Article 31C begins with a non-obstante clause by putting Article 13 out of harm's way. It provides for a certain consequences, notwithstanding anything contained in Article 13. If it that denudes Article 14 and 19 of their functional utility by providing that rights conferred by this article will be no barrier against passing laws for giving effect to the principles laid down in Part 4. On the reasonable interpretation, there can be no doubt by the amendment introduced by Section 4 of the 42nd Amendment, Article 14 and 19 stand abrogated, at least in regard to the categories of laws described in Article 31C. The startling consequence which the amendment has produced is that even if a law is in total defiance of mandate of Article 13, read with 14 and 19, its validity will not be open to question so long as its object is to secure a directive principle of state policy. We are disposed to accept the submission of the learned Solicitor General, considering the two charts of cases submitted by him, that it is possible to conceive of laws which will not attract Article 31C, since they may not bear direct and reasonable nexus with the provisions of Part 4. But then, in our opinion, is beside the point. A large majority of laws, the bulk of them, can at any rate be easily justified as having been passed for the purpose of giving effect to the policy of state towards securing some principle or other laid down in Part 4. In respect of such laws, which will cover an extensive gamut of relevant legislative activity, the protection of Article 14 and 19 will stand wholly withdrawn. It is then no answer to say, while determining whether the basic structure of the Constitution is altered, that at least some of the laws will fall outside the scope. Now 75. We may have a serious issue with 31C, but someone will have to lay a challenge, not on the ground that it doesn't revive. And that challenge, will have to be met with by us. There is no challenge.
It is struck down. So nobody can challenge it.
Lord, it is upheld by 13 judges as in Keshwanand Bharti.
Reason, you see paragraph 58, the reason why it is struck down is
It's not struck.
shutting out an argument under Article 14 and Article 19
Lord,
on the basis of fundamental rights to a law is against the basic structure.
Lord, substitution is struck down. Section 4 of the amending act is struck down. 31C is upheld by 13 judges.
Talking in 1980, what happened? Once Section 4, the amendment is struck down, what remains? The previous provision and the subsequent provision are in pari materia. In fact, the expansive provision is struck down, the limited provision goes with it.
Lord, I won't be able to go beyond saying that it is
the same thing in para 61. See para 61 also.
Lord, I leave it to you, Lord.
Para 61 also see. Articles 14 and 19 do not confer fanciful rights. They confer rights which are elementary for the proper and effective functioning of a democracy. Then they say, if Articles 14 and 19 are put out of operation in regard to the bulk of laws which the legislatures are empowered to pass, Article 32 will be drained of its lifeblood. Then they continue, then the power to take away the protection of Article 14 is the power to discriminate without a valid basis for classification. And then in the end they say, the nature and quality of the amendment introduced by Section 4 of the 42nd Amendment is therefore such that it virtually tears away the heart of basic fundamental freedoms. This is what they say in these two paragraphs.
No, may I have 5 minutes?
No, I wanted to read, my lord. Kindly note, my lord, few paragraphs. I will not read it, my lord. Now that your lordship, my lord, seems to be convinced, my lord, on this. But para 75, my lord, for my satisfaction, for whatever.
75.
This, my lord. 75, my lord, at page 2085.
Yes.
62 is also.
Then these then are our reasons for the order which we passed on May 9, 1980 to the following effect. As my lords were saying, my lord, the operative part was pronounced first.
Here it says May 9th, May 9th.
Pardon?
Although it was passed in August 80, specifically says these are for reasons the order were passed on May 9th. It will be read as if it was passed
Judgment
on May.
later.
Yeah, the reasons came later. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic or essential feature of the Constitution. Lord, please keep Section 4 on the side, my lord. Page 3966. Please keep it on the side. Volume 4. 3966. Volume 4. And what Minerva Mill does. Lord, I have that, my lord, 3966, volume 4. Your lordships have that, my lord?
Yes.
I may read, my lord, for the benefit of everyone, my lord. In Article 31C of the Constitution, for the words, brackets, letters and figures within comma, the principles specified in clause B or clause C of Article 39, the words and figure within inverted comma, all or any of the principles laid down in part 4, comma over, shall be substituted. Correct, my lord? So now they say that every entire chapter protects any challenge. Now the court, my lord, in the para 75 says in Minerva Mills, section 4 of the Constitution 42nd Amendment Act is beyond the amending power of the Parliament and is void since it damages the basic or essential feature of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or 19 of the Constitution if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4. The substituted part, Section 55 of the amendment is beyond the amending power with which we are not concerned. So what is set aside is 4. And thereafter, my lord, Vaman Rao deals with this and says that the position prevailing before 42nd Amendment Act in 31C stands restored.
They don't say that in Vaman Rao. They don't say that there is a revival. Vaman Rao doesn't use the expression revival or restoration at all. Very careful. We saw Vaman Rao. We'll give you.
Lord, would your lordships come to volume 2B, page 8? Volume 2B, page 8. Your lordships gets one?
Yes.
My Lord Justice, sir. This is Vaman Rao. After Minerva Mills, after noting Minerva Mills, after noting that this bracketed portion is set aside or declared unconstitutional, holds this. Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of the Constitution 42nd Amendment Act, which I read, is valid to the extent to which its constitutionality was upheld in Keshwanand Bharati. Article 31C, as it stood prior to the Constitution 42nd Amendment Act, does not damage any of the basic or essential features of the Constitution or its basic structure.
But this is prior to the substitution. The issue of revival was never dealt with.
After the substitution, my lords. I may be, my contention may be wrong. Factually, I'm right.
Actually, it's not so, because it says that 31C, as it stood prior to its amendment in 1976, is valid to the extent to which its constitutionality was upheld in Keshwanand. So it only tells us what is the decision in Keshwanand, namely that 31C prior to Keshwanand and as upheld in Keshwanand is valid. That's all.
Further,
it does not deal with what is the effect of the substitution having been struck down. That's not here at all.
Right.
Lord, it deals with 42nd Amendment, my lords. 42nd Amendment.
We have to deal with it. Vaman Rao doesn't give us an answer. Vaman Rao doesn't give us an answer to the conundrum.
Probably we lots of
We have
look at
to.
it like this. This paragraph stands on the same footing as paragraphs 413 of NJAC judgment. It stands on the same logic and the same footing. It doesn't have to expressly say so. The conclusion is well drawn from it. Otherwise, the theory of vacuum would probably equally apply to every situation when
There's no vacuum here. That's the problem which you face.
there's a vacuum in the law.
There
It's
could
not
be a
about-
vacuum. Parliament wanted a protection.
There's no vacuum in the law.
No, the vacuum in the, yes.
The law doesn't become, there would be a vacuum if the law.
Lord, can I put it a little candidly? Can I put it?
The law still can benefit from the presumption that a law made to give effect to a directive principle is presumed to be reasonable.
Lord, can I put it a little candid? Can I put it a little candidly? 31C, as we read it, we find it difficult to accept the proposition that it is not even, it is immune from challenge. But Lord, it will have to be challenged in an appropriate proceedings. This may not be a proper procedure to declare 31C as non-existent.
The immunity, so they're entitled to say that the immunity doesn't apply. There's no question of challenging it.
There's no need to.
Once you set up the immunity, you can argue that the immunity does not
I would
apply.
still urge this, Your Lordship, say that the vacuum principle is squarely upheld because what remains after 31C, second part gone, the first part gone,
Lord,
nothing remains.
It's
Therefore, there is a
difficult, my
vacuum.
Lord, to accept immunity,
There's a complete
but
vacuum.
not by not revival doctrine.
Deprivation of an immunity as a matter of constitutional concept is not a vacuum because the law is still presumed to be valid. The presumption of constitutionality.
IR Polo takes care of that.
It is
Coelho takes care of
it. That's all. It's only that it has to be justified.
If 31C had a
Lord,
legitimate place in the
Lord, may I-
Constitution, it had a legitimate place in the Constitution.
Alright, I
Minus
think what
what's
you-
like an amendment it would have had.
You've got your point. You've got your point. I mean, this is not a matter which is free from difficulty. Mr. Dwivedi, would you like to add? And then we'll call upon Mr. Andar.
Yes, no.
My Lord, only, my Lord, before that.
Position prior to
Only one.
What we'll do is, we'll hear Mr. Andar because we have not heard him. We'll have to put our doubts now to him as well.
Just
Lord,
3
two
minutes,
paragraphs,
I'm
my
not
Lord, can I complete? Of NJSC.
Oh, sure.
And my Lord, please avoid, my Lord, for the time being, don't keep, my Lord, that constitutional breakdown in mind. But it's not necessary. My proposition is that it is only when constitutional background is the result that revival does not take place, and in other provisions it takes place. Either it takes place or it does not take place. That's my Lord, that's a respectful submission.
If we go by your theory of revival.
Para 5.
Article,
Wait, what?
if you go by the theory of revival, if Article 31C is now struck down, what revives is the position prior to Article 31C. That means the immunity goes.
Lord, if the Honorable Court believes it is struck down, Lord, I have nothing to say, but it is not. I don't think the other side says it is struck down. It is upheld in 13 judge judgment. It's not struck down. The amendment of 42nd amendment is struck down. But I leave it at that. No, I can't.
Which other paras, Mr.
Lord, 4106, volume 5.
106.
Para 989. No, this is a concurring view of Justice Joseph. Justice Kurian Joseph. Your Lordship gets, my Lord? One word on the consequence. Though elaborate arguments have been addressed that even if the constitutional amendment is struck down, the collegium. I'm sorry, my Lord Justice Padiwala gets, my Lord? One word on the consequence. Though elaborate arguments have been addressed that even if the constitutional amendment is struck down, the collegium does not resurrect, according to me, does not appeal even to common sense. The 99th amendment sought to substitute a few provisions of the Constitution and insert a few new provisions. Identical situation to 42nd amendment. Once the process of substitution and insertion by way of a constitutional amendment is itself held to be bad and impermissible, the pre-amended provisions automatically resurface and revive. That alone can be the reasonably inferential conclusion. Legal parlance and common parlance may be different, but there cannot be any legal sense of an issue which does not appeal to common sense. That you, instead of X, you substitute with Y. The court says that Y is not a valid substitution. Then X would revive, rightly or wrongly, this is what it says. And the last, Lord, page 4156. Lord, the same judgment, Justice Goyal's view, my Lord, para 1110. 1110, my Lord, page 4156. All the three honorable judges have, my Lord, dealt with this issue. May I read? I'm sorry, my Lord Justice Pandiwala. Only a minute, my Lord. My Lord Justice Pandiwala. Placitum H at the foot.
The foot.
May I read, my Lord Justice? Well, this is the view of my Lord Justice Goyal, my Lord. The contention that even if the amendment is held to be void, the pre-existing system cannot be restored has no logic. In exercise of power of judicial review, a provision can be declared void, in which case the legal position as it stands without such void provision can be held to prevail. It is not a situation when the position has not been made clear while deciding an issue. Power of this court to declare the effect of its order cannot be doubted, nor the decisions relied upon by the respondents show otherwise. I hold that on amendment being struck down, the pre-existing system stands revived. No, none of the honorable two judges do not mention about any breakdown. They, as a proposition of law, that you have substituted X by Y, Y is declared unconstitutional. Therefore, X revive. That's the word used. That's my. We'll elaborate, if needed.
Please bear in mind that the substitution happened by virtue of Section 4. Section 4 enlarges. It's a substitution by enlargement. This court holds that this is against the doctrine of basic structure and therefore void. It's very important. Whole of Section 4 is void.
Just a second.
There are numerous judgments.
Substitution of original took place by
Section 4
enlargement.
by enlargement
This one.
or expansion.
By expansion. And second, you said Section 4
was declared null and void by exercising the doctrine of ultra vires on account of destruction of the basic feature of the Constitution. One, my lords, there are numerous judgments of this court without dissent that, including in the context of Article 13, that if a law is declared to be void, then it is void stillborn, void.
There is controversy on it, whether it is stillborn or it becomes void from the date of the declaration. That,
So,
just Matthew's judgment in Ambika.
so I would prefer to use void ab initio. The stillborn would mean it never operated, but what happens is that generally there is a time lag between the making of the constitutional amendment and the declaration of ultra vires by the court. So in the interregnum,
Acts may have been taken
that
place.
some things may have been done. So whenever a lordship declares ultra vires, a question arises: what should be the form of declaration?
You say what happened.
Whether a lordship will protect or not protect. But one thing is certain, that the law, unless made prospective, operates retrospectively from the date the law came into operation. So unless your lordship gives it prospectivity, partial prospectivity, retrospectivity with protection.
The law was never enacted.
Never enacted. So if Section 4 is to be held to have never been enacted by virtue of this declaration in Minerva Mills, then the logical sequitur is that the Section 31C, as upheld in Keshwanand Bharati, stands as part of the Constitution. There is no question of revival, resurrection. That's a misnomer, my lords. It stands. It was never substituted. Something which is void ab initio can never substitute. So Sections 4 was dead or declared dead retrospectively. There is no prospectivity attached, my lord, in the declaration in the Minerva Mills.
Yeah, now we got the point. We'll hear Mr.
The other thing is, my lord, there's one more thing. Something absolutely inherent in the word substitution. Please have Section 4, para 412.6 of the judgment which our lordships were reading. Page 3883. An earlier three-judge judgment has been approvingly referred to in the context of what is substitution.
This is what? What are you referring to?
Page 3883. Yes, NJAC judgment, which our lordships were considering. Central Provinces Manganese Ore Company, this is three-judge judgment, which is relied upon for revival. direction.
2016, volume 5, SS.
Yes. Paragraph.
1977.
Huh? No, not that. NJAC is illogical. Reference was then made to central provinces, manganese ore. We do not think that the word substitution necessarily or always connotes, I'm sorry, paragraph 412.6 at page 3883. The chart is slightly defective. It suggests as if that portion is struck down. It's the entire section 4 which is struck down.
It is created by, it's a confusion created by the chat. No, it's our confusion.
By us.
Chat.
By us. So just read this, para 412.6. Kindly peruse this, 412.6. We do not think that the word substitution necessarily or always connotes two severable steps. That is to say, one of repeal and another of fresh enactment, even if it implies two steps. Indeed, the natural meaning of the word substitution is to indicate that the process cannot be split up into two pieces. Like this, if the process described as substitution fails, it is totally ineffective, so as to leave intact what was sought to be displaced. That seems to us to be the ordinary and natural meaning of the word shall be substituted. This part could not become effective without the assent of the Governor General. The state governor's assent was insufficient. It could not be inferred that what was intended was that in case the substitution failed or proved ineffective, some repeal not mentioned at all was brought about and remained effective so as to create what may be described as a vacuum in the state law. So maybe vacuum or not is not the question at all. Question is substitution is an amalgam. It repeals and replaces something. So it can't be that in part it is struck down, gone, but the repeal part remains. That's what this judgment said.
It was never there. It was never born because assent was not there.
No.
In this case, it came into effect, substitution was done, and then declaration.
No, the point is that once your lordship declares the substitution itself to be void. See, what are we reading? How do we read section 4 now? What are we reading? We are reading it as if section 4 have those struck down as void in Minerva, yet the substance of the amendment goes, the old doesn't revive, so it's a repeal. So the repealing effect is surviving. The repealing effect of section 4 is surviving. Therefore, notwithstanding the declaration that it is void. How can that happen, my lord? We are splitting up the declaration of the court in Minerva Mill. Part is void, part is surviving. Section 4 reads, this will be substituted. 4 is gone. So where is the substitution? So in a matter of substitution, it's an amalgam. The going out and the coming in are one intertwined act of the legislature. The whole goes. Unless the court splits it up, having found that it is severable, then of course the lordships can say that we are striking down this part of it, but we are not reviving. That the court never said. It declares the whole entirety of section 4 null and void. So it can't have a split effect. The third thing was, I'm not elaborating. There are numerous judgments which I can cite, but I'll do it when my turn comes. But the third and more important is, what is this doctrine of basic structure under 368? The doctrine is that if you damage the basic structure, then what you are doing, your act, is beyond your competence under 368. So the amendment which brought about the enlargement is been held in Minerva Mill to be beyond the competence of the Parliament under 368. So what is beyond the competence, my lords, cannot have any effect at all. It can't be that it was beyond the competence, yet in part, in some little part, it is still surviving to have the repealing effect of what was upheld by 13 judges. And it has dangerous consequences, as what the learned solicitor said, which a lordship, of course, will elaborate. What all can be amended, and then, my lords, every time this court will be, my lord, be troubled with this. How much of it is, my lord, reviving or not reviving? In my submission is quite contrary to Mr. Nariman's. He says, refers to that expression, stands part of the Constitution. That's what in Article 368 is, that once the bill is passed, it stands amended in terms of the bill. But he misses the expression which is earlier. Once it is passed and assented thereupon. Now, if it could not be passed, once it is void, it could not be passed, it could not be assented. So there is no question of the thereupon effect following. That is stands part. Merely because the ultra-virus declaration comes, Lord, after a decade, it doesn't mean that it was the last 10 years competence. That's a thing.
Can I just take 2 minutes? I'll just
We'll now hear everybody later. Mr. Andarujana.
I'll just supplement 1 minute.
Get your full turn now. You get your full turn. There were 3 counsel on one self-evident proposition. Now, Mr. Andarujana.
Only 2 dates.
Let him argue.
2 dates.
In response, yes. Mr. Andarujana, please start now.
First of all, Lord, I want to express my gratitude to your lordships for taking up this point, Lord. But it is an important point, a point particularly important for the facts of this case. Lord, I fully understand the concerns expressed by my learned friends, Lord, the Solicitor General, the Attorney General, Mr. Dwivedi. But regretfully, my Lord, I disagree with almost every statement of law that they have made. Lord, Mr. Nariman's point, my Lord, in my respectful submission, is a point which carries great force and a point which requires a determination by your lordship's bench. Now, my Lord, I have divided my arguments, my Lord, into 4 segments. But I'd just like your lordship broadly to know how I wish to address your lordships today. Lord, I will just frame the issue before your lordship precisely, because I think, Lord, it is important that we understand that we are dealing with the effect of a declaration of unconstitutionality on a substituted provision in the Constitution. And that is the precise issue. But I'll just frame it in a moment for your lordship.
Just
and I will say,
effect of the declaration of a substitution, declaration of unconstitutionality.
Yes, Lord.
Just one second.
Yes, Lord.
Effect of the declaration of unconstitutionality on a substituted provision
in the Constitution. And, my Lord, and I think it is important, my Lord, that we bear in mind the distinction of this issue from other legislative activities such as repeal and introducing new laws. Lord, it is an important distinction to be borne in mind in my respectful submission. My Lord, I hope that I will persuade your lordship, so that is the case. My Lord, my Lord, the first part, my Lord, I wanted to address your lordship on, my lord, which will nail, my lord, to the mast, my lord, with some certainty, my lord, what exactly factually took place. My lord, so much will become evident from that, because I will show your lordship that for 20 years, in fact, for about 22 years, my lord, there was no Article 31C did not exist in the Constitution at all. It came in later. Lord, I'll also tell your lordship, Lord, in a nutshell, my lord, about the reasons for introduction of Article 31C. Lord, there is no constitutional chaos which is going to result, as your lordship alluded to, for different reasons. Lord, I also want to set out, my lord, how the Minerva Mills judgment came to be. And I want to point out to your lordship that actually the problem is a problem post Minerva Mills. So it is a problem post 1980. So Lord, if we bear that in mind, but the issue that we have is a post 1980 issue, but that will all become evident, my lord, in my legislative history. My lord, the third issue which I want to address your lordships on, so the first was to frame the issue correctly. My lord, the second, my lord, was to deal with legislative history very swiftly, my lord. I won't take your lordship's time on that. And my lord, the third, my lord, I wanted to deal with the effect of Lord Minerva Mills, Vaman Rao, and the successor judgments. My lord, there are in particular two, my lord, Sanjeev Coke Mills, Sanjeev Coke, and the other one is the Bhim Singh Ji judgment. My lord, and also, my lord, there's another judgment called Basanti, my lord, which actually dealt with a 31C challenge to MHADA itself, where also, my lord, 31C was noticed and the learned judges proceeded on the basis that in fact it was valid. So, Lord, I'm going to show your lordships all of those. Lord, I hope to immediately and swiftly show your lordship that Minerva Mills clearly proceeded on a concession which was made by Mr. Palkiwala, Lord, who was arguing the case. But the issue in fact never arose in Vaman Rao, which will also become evident from the dates in my legislative history. It could not have arisen because the question of striking down was not before the court in Vaman Rao at all, for that simple reason. But, Lord, I hope to elaborate on that. Now, Lord, I also, Lord, in the next segment of my arguments, Lord, want to deal with the NJAC judgment because, Lord, it is, I did find it, Lord, curious that my learned friends relied upon it because that judgment, Lord, was a judgment I wanted to rely upon. Lord, it entirely, in my respectful submission, Lord, supports my arguments, as I will show you, Lordship. Lord, and it distinguishes, of course, that amendment as saying that that amendment was not a substitution. Now, that really, my Lord, is the short point with regard to the NGSC judgment. I hope to make that good. And it otherwise, my Lord, fully accepts, my Lord, the submission that in fact there is no doctrine of automatic revival. My Lord, the last part of my address, my Lord, is on the consequential aspects in the event that I am to succeed. My Lord, there will be no, my Lord, constitutional chaos. There will be no crisis, as I will show your Lordship. And to your Lordship's very pointed question about whether this is purely a technical point, in the sense that Parliament can always step in and take the necessary steps to redress it, Lord, I'll make a few comments on that. So, Lord, that is how I propose to go about this. My Lord, my time estimate, my Lord, is approximately 2 to 2.5 hours, if your Lordship will permit me that. Lord, so, Lord, I will straight away start, my Lord, by, if your Lordships don't mind, my Lord, I have prepared a note on this. My Lord, I have prepared a note on this. My Lord, the note is actually what I gave your Lordship yesterday and the same note from which I argued the Coelho point. My Lord, today, my Lord, I will be relying on serial numbers 1 and 3. My Lord, the note has an index in front, if your Lordship will see it. My Lord, it has 3 items, but Roman 1 is legislative history and Roman 3 is whether 31C is a dead letter. But, my Lord, before I go to the note, my Lord, I wanted to, my Lord, give your Lordship, my Lord, a brief overview of the legislative history. My Lord, it is not even necessary to read this note. My Lord, I think I can effectively bring it out in a few minutes before your Lordships. Or do your Lordships have the note, just so that...
Where is your note?
My Lord, it's 1B in the Google Drive, 1B.
Volume 1B.
Lord. The name is note tendered by Mr. Zalti on the original, senior advocate.
I've got a lot of...
Legislative history of Article 31C.
Yes, no, my Lord, it says, yes, legislative history of 31C of the Constitution is the first item, relevant to the present case. It's not a general history, my Lord, relevant to the present. But if all of your lordships have it,
Just 1 second.
yes, please.
I have one which is garbled, the garbled version. Let me see if
Please.
start. Okay. Yes. Now you can communicate. Yes.
Lord, so Lord, it is a longish note. So Lord, I'll just summarize it first to your lordships. Lord.
Yes.
Lord, just your lordships will kindly mark one date, my Lord. That is item 5 of my list of dates. Lord, that is 20th April 1972. And that is the date of insertion of Article 31C.
What are you reading? Which page?
Lord, it's page 6, PDF page 6.
Yes.
So, Lord, your lordship will just note that date. Now, Lord, I first wanted to address your lordship on some constitutional events prior to that. Lord, on 18 June 1951, we have the First Amendment. Lord, just orally, Lord, just a few minutes. Lord, the First Amendment, Lord, introduces Article 31A and Article 31B. Lord, the speeches piloting it through Parliament, Lord, which are given by Pandit Nehru, Lord, all indicate that it is really for the purpose of agrarian reform. Lord, which was one of the important platforms for Lord of the Congress Party back then. Lord, it is immediately challenged, Lord, in Sankari Prasad's case in 1951. Lord, Sankari Prasad's case, the challenge is whether 31A and the amending law of the Constitution amounts to law under Article 30. Lord, and the question is therefore, if constitutional law is law as understood under Article 13, Lord, if it is law as understood under Article 13, then the effect of that on Part 3 was to be considered. Lord, Sankari Prasad rejects that challenge. But several years later, in Sajan Singh's case in 1965, Lord, Sankari Prasad's view is upheld. Lord, in 1967, Lord, we have Golaknath's case. As your lordships know, Lord, Golaknath resulted in a 6-5 majority. Lord, and the effect of the 6-5 majority was to hold that Section 368 is not the source of the amending power of Parliament. It is a general power that the Parliament has. And that Article 13A, law, constitutional law, is the law which, my apologies, Lord, that the law under Article 13A is constitutional law, namely the law which is used to amend the Constitution from time to time. Now, Lord, as a result of Golaknath's judgment, your lordship knows that Golaknath then set out the principle of prospective overruling, which was till then, Lord, actually a concept which was alien to our jurisprudence. But, my Lord, as a result of this, my Lord, there was a severe limitation, my Lord, which was then placed on the constituent power of Parliament. But Parliament reacted, my Lord, by introducing 2 amendments. My Lord, the first amendment was on 5th November 1971, which was the 24th Amendment. Lord, they made certain amendments to Article 13 and in Article 13.4. Lord, and they made significant amendments then to Article 361 and to the marginal note, effectively making it clear that Parliament had an unlimited power to amend.
Yeah.
But on 20th April 72, then they introduced the 25th Amendment, that is Article 31C. Now, not my point, not my limited point, but thus far is this. Not that from inception, Lord, Article 31C did not exist. Article 31C came about as a parliamentary reaction to the judgment of the Supreme Court in Golaknath's case. So, my lord, it was to some extent, my lord, in the parliament, the tension between parliament and the court manifested itself in the 25th Amendment, namely on 20th April 1972. So, my lord, from the date of inception to the Constitution till 72, my lord, chaos did not reign. My lord, there was no anarchy in the country. My lord, the constitutional provisions remained as they were. And my lord, if I am right, my lord, we will revert to that position, my lord, prior to 1972. Now, my lord, Keshav Nanda's judgment, my lord, comes immediately, shortly thereafter, because, my lord, in fact, my lord, the 25th Amendment is immediately challenged, as your lordship knows. One of the aspects which is challenged in Keshav Nanda's judgment. And, my lord, we have the judgment then on 20th April 1973. My lord, Keshav Nanda's judgment notices the basic structure, my lord, which is then further commented upon in Indira Gandhi's case. Now, my lord, we have the 42nd Amendment, which comes on 18th December 1976. Now, my lord, the 42nd Amendment, my lord, has the effect of expanding Article 31C. And your lordship will find this, my lord, in my list of dates, if your lordship will kindly look at PDF page 12. But I'll just read to your lordship, so your lordship has in an orderly manner, Lord, what the amendment did. But your lordships, all of your lordships have that. But it's item 8, page 12.
PDF page 12.
Yes, Lord. PDF page 12.
And there you have that section 4, which we read from Minerva Mills.
Yes. But I quickly just breeze through it to give your lordship a comprehensive view. The Constitution 42nd Amendment Act, inter alia amending Article 31C, received the assent of the President of India. The amendments were as follows. Insertion of new subheading after Article 31. After Article 31 of the Constitution, the following subheading shall be inserted, saving of certain laws. 4. The amendment of Article 31C. In Article 31C of the Constitution, for the words, brackets, letters and figures, the principles specified in Clause B or Clause C of Article 39, the words and figures, all or any of the principles laid down in Part 4 shall be substituted. Well, there was also then an amendment which was made to 368, well, which is not really relevant, but for the sake of completeness, my lord, I have set it out to your lordship. Now, but if your lordship will then go down to item 9, my lord, how did it stand as a result of the amendment? I've set it out there. My lord, the amended, well, this is at PDF page 13. The amended Article 31C read as under, saving of laws giving effect to certain directive principles, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any rights conferred by Article 14, 19 or 31, no law containing a declaration that it is for giving effect, so on and so forth. But as we know, part of it, was then subsequently set aside. Now, if your lordship will just go to item 10 and kindly note the date also. In 1977, the writ petitions were filed under Article 32 in the Honorable Supreme Court in Minerva Mills and Union of India, inter alia challenging the constitutional validity of Section 4 and Section 5 of the Constitution 42nd Amendment Act 1976. The writ petitions under Article 32 filed in the Honorable Supreme Court in Vaman Rao versus Union of India, inter alia challenging the constitutional validities of 31A, 31B, and unamended Article 31C. So, these two matters, have historically always moved in step and moved together. Now, a very interesting development takes place immediately thereafter, which I want to bring to your lordship's notice. On 15th May 1978, the Constitution 45th Amendment Bill, so this is the bill of 1978, which is Bill 88 of 78, to further amend the Constitution of India was introduced in the Lok Sabha. clause 8 of the bill read as follows. So, my lord, this was an attempt by Parliament. My lord, the government had now changed, and it was an attempt by Parliament to actually once again narrow the effect of Article 31C, as your lordship will see. So, my lord, the amendment, my lord, and my lord, 8 of the amendment read thus.
They wanted to restore the position as it was prior to the 42nd Amendment.
Exactly. My lord, they wanted to restore the position as it was prior. My lord, and as I will show your lordship, my lord, from this, actually, my lord, the bill, my lord, of course, my lord, passed as an act, but without this portion being passed by the Rajya Sabha. So, my lord, if your lordship will just permit me to read this through, my lord, that will become evident to your lordship. My lord, for the words, figures, all or any of the principles laid down in part 4, the words, brackets, letters and figures, the principles laid down in clause B or clause C of Article 39 should be substituted. So that is what they wanted to bring back. For the words and figures 14, 19 and 31, the words and figures Article 14 and 19 shall be substituted. Now the second part was successful. Lord, 31 stood deleted. The first part was not. The words "and no law containing a declaration that is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy shall be omitted." Now, my lord, that was the portion. That was the portion which had been dealt with by Keshav Nanda.
Proposed bill which never passed the Rajya Sabha. So 31, 19(1)(f) was deleted, 31 was deleted, but this remained as it is.
Exactly, this remained as it is. And not of note, my lord, is the deletion also. Lord, when and why? Lord,
Omission of what?
Now, Lord, if I may just read the notes.
Yes.
Sorry, if I just read the note to that, my lord. The notes on clause to clause 8 read as follows. The amendment proposed in subclause A or this clause is for confining the protection afforded to Article 31C only to the laws giving effect to the policy of state towards securing the directive principles specified in clauses B and C of Article 39. This would have the effect of restoring the article to the form in which it stood before the amendment made to the article by the Constitution 42nd Amendment Act 1976 came into force. The amendment proposed in subclause B is consequential to the omission of Article 31 above. The amendment proposed in subclause C is for omitting the portion related to the declaration contained in Article 31C, which was struck down by the Supreme Court in Keshav Nanda Bharati. Now, Lord, that is a point which I want to develop a little later on. What is the effect of a declaration of unconstitutionality on a constitutional provision? Lord, it is now, I respectfully submit, an accepted position that it does not get excised from the statute book. It remains in the statute book, and it actually has to be removed by Parliament. And Lord, of course, the relevance of this point is that the pronouncement by the courts on the constitutionality of the articles of the Constitution, in my respectful submission, invariably require a consequential parliamentary action. So that's a point that I hope to develop for your lordship, Lord, as we go along. Lord, the bill also sought for a deletion of Article 19(1)(f) and Article 31 and the insertion of Article 300A. Now, about the fate of that bill, what exactly happened to it is at item 12. The Constitution Bill was considered by the Rajya Sabha. During the consideration of the 45th Amendment Bill by the Rajya Sabha on 31st August 1978, the motion for retaining Clause 8 as a part of the bill was put to vote. The motion was not carried by a majority of the total membership of the House and by a majority of not less than 2/3 of the members present and voting. Note, the proposed amendment of 31C in terms of Clause 8A of the Constitution Bill was thus omitted from the bill by the Rajya Sabha. Thereafter, a consequential amendment to 31C was moved under Clause 7A. Lord, I'll just read it, Lord. Shri Shanti Bhushan, may I have your permission to move a consequential amendment now that Article 31 has been deleted by the adoption of Clause 6? Reference to Article 31 in Article 31C is inappropriate. Therefore, I'm moving Amendment 103 that the page after line 4, the following new clause be inserted, namely in Article 31C in the Constitution for the words and figures, Article 14, 19 and 31, the words and figures, Article 14 and 19 shall be substituted. So Lord, that is how, Lord, Article 31 came to be deleted from Lord, I'm sorry, but that is how, Lord, the mention of Article 31 came to be deleted from Article 31C. But clause 7A was thereafter put to vote. The motion was carried by a majority of total membership of the House and a majority of not less than 2/3 of the members present and voting. Now, Lord, as a result of this, what did Article 31C look like? I put that out in 13.
Yes, Mr. Chandrachud.
Please, Lord. Lord, the result, Lord, what Article 31C now look like, Lord, as a result of this legislative process, Lord, I've set out at item 13 of my list of dates, page 70. Lord, the saving of laws giving effect to certain directive principles, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent or takes away or abridges any of the rights conferred by 14 and 19. So 31 stood. Now, Lord, now we come to Minerva. Lord, if your Lordship will turn to page 18 of my list of dates. Lord, on 9th May 1980, Lord, we have the order in Minerva Mills case. Lord, the Chief Justice, Justice Chandrachud, P.N. Bhagwati, A.C. Gupta, N.L. Undwalia, and P.S. Kailasam. Lord, 5 judges. Inter alia holding, or this is of course the majority view, that Section 4 and Section 55 of the Constitution 42nd Amendment Act to be void on the ground that it destroyed the basic structure of the Constitution. Now, Lord, I've only extracted here, not some part of the order. But Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of Parliament and is void since it damages the basic or the essential features of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19 of the Constitution if the law is for giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 of the Constitution. And as far as 55, just for the sake of completeness, Section 55 of the Constitution is beyond the amending power of Parliament and is void since it removes all limitations on the power of Parliament to amend the Constitution and confers power upon it to amend the constitution so as to damage or destroy its basic or essential features or its basic structure. So what section 55 was that section that brought about amendments to 368, not giving Parliament plenary powers to amend. Note, the reasons for the decision were given in the judgment on 31/7/1980. Your Lordship said August. Your Lordship is not entirely wrong. Or 31st of July 1980. See Minerva bills given below. Lord, there is a typo I noticed in one of the other judgments which refers to May. It is actually delivered on 31st July 1980. I think Justice Bhagwati's judgment states the date incorrectly.
Actually, right. 31st July 80 was post the vacation probably.
Yes, yes. The day Abhinav was born.
Now, Lord Vaman, sorry. So, my Lord, I just referred to the judgment and the reasons coming later. But on the very same day, we have the judgment in.
This is something which we'll have to bear in mind, that though Minerva strikes down the entirety of Section 4 of the 42nd Amendment, by virtue of which all or any of the principles in Part 4 is struck down, Vaman Rao, for which the reasons are delivered later, Vaman Rao upholds 31C to the extent to which it was upheld in Keshwanand.
Unamended.
That is the unamended. Section 30, Article 31C.
Because unamended was challenged there.
Right.
Not the amendment was not a
The
subsequent.
amendment of Vaman Rao.
And Vaman Rao is subsequent in time.
No, what was challenged in Vaman Rao was the unamended.
Yes, the original because it came from High Court.
By then, Keshwanand had been delivered.
Yes.
So they say that.
No, interestingly, that's what because if we see Minerva came in July, Vaman Rao came in November, in spite of noting that it has been set aside in Keshavan. After that, a separate finding has been given, independent finding to say that unamended is declared unconstitutional.
Correct. What is the basis of that?
No, the interesting
Unamended is the challenge.
That has been equated with 31A principle, Manas. To say the 31A, independent of Keshavnath, the independent 31A principle applied, and interestingly, by that time, Minerva was in hand. We had a judgment on that day.
Yes, Mr.
Lord, I am obliged to my learned friend, Lord, and he is undoubtedly correct in that. Lord, that the Vaman Rao rationale for upholding the unamended 31C was on an equivalence with 31A, which is what I will point out. But Lord, the point of relevance, Lord, for the present argument is that this question with regard to the unconstitutionality of a substituted provision was never present before the judges in Vaman Rao's case. For the simple reason that when the hearing stood concluded, the result of Minerva Mills was not. So, my Lord, the judgment could really never tackle this issue. But I'll come to the separate point about what is the effect of, Lord, that declaratory statement which is made in Vaman Rao. But this issue which we are dealing with, but precisely this issue was not present in Vaman Rao's case either. Not for this reason, or for this coincidence of time. So, Lord, we then have I'll just finish this in a few minutes, Lord, we're coming to the end, Lord. On 9th May 1980, Lord, item 15, Lord, we have the Vaman Rao order. Lord, and here we have Chief Justice Chandrachud, Lord Justice Bhagwati, Justices Krishna Iyer, Tulsapurkar, and AP Sen. Lord, it's reported in 1983 SCC, 5 judges upholding the validity of unamended Article 31C to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. Article 31C of the Constitution, as it stood prior to...
My brother Justice Roy is saying something.
No, I'm just going to say that instead of saying Chief Justice Chandrachud, you can say Chief Justice Chandrachud 1.
Lord, present, I will take your Lordship's advice on that. Lord, perhaps as the former Chief Justice Chandrachud.
Equally a senior.
Lord, it is a problem which doesn't come to council very often, Lord. It is a problem which presents. my lord, so my lord, the judgment in Vaman Rao is delivered. My lord, and the extract is there, my lord. Article 31C of the Constitution, as it stood prior to its amendment by Section 4 of the Constitution, 42nd Amendment Act 1976, is valid to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. Article 31C, as it stood prior to the Constitution Amendment Act, does not damage any of the basic or essential features of the Constitution or its basic structure. The effect of the substitution of the words all or any of the principles laid down in Part 4 for the words principles specified in Clause B or C of Article 39, effected by the 42nd Amendment, was not at all considered. Now, my lord, thereafter we have the judgment in Minerva Mills on 31st July 1980. My lord, the judgment is far too important to try to summarize. My lord, I will take your lordship to the relevant passages. But for your lordship's convenience, my lord, I have tried to summarize it, my lord, by referring to various passages at page 20. Now, my lord, I will not deal with the note here, my lord, because I'll make my submissions on Minerva Mills case, my lord, separately. My lord, I just want to point out to your lordship in conclusion of my list of dates, 2 or 3 more dates. On 13th November 1980, we have the judgment in Vaman Rao. My lord, once again, my lord, it is a matter of great moment to this argument. My lord, I will read from the judgment itself, if your lordships don't mind. And my lord, then we have 2 or 3 other interesting developments. My lord, on item 18, so my lord, once again in 1980, we have 3 very, very important judgments, all dealing with Article 31C. We have the third of those judgments, my lord, which is on 13th November 1980, the order passed in Bhim Singh Ji's case. Now, Bhim Singh Ji's case.
Remember comes Bhim Singh Ji.
Yes, Bhim Singh Ji. Now, my lord, Bhim Singh Ji's case was the case which was referred to by my lady yesterday, my lord, in the context of the urban land sealing challenge. As my lady knows, my lord, in Bhim Singh Ji's case, the result of the majority was to strike down only one section, which was 27(1). But Lord, the effect of Bhim Singh Ji, Lord, is a very neutral effect on this argument. Lord, for reasons that I'll come to when I deal with the judgment individually. Now, Lord, your lordship will only note, Lord, relevant to the facts of this case. Item 19, on 26 February 1986, Chapter 8A of Madar is now introduced. So, Lord, just to contextualize it, Lord, to the facts of our case, Lord, this happens there. And, my Lord, sorry, my, I seem to have omitted to mention to your lordship one relevant date, my lord. Item 16, I'm afraid I failed to read that, my lord. Lord, if your lordship will see the note, Lord, the judgment in Minerva Mills also referred to Sanjeev Coke. Lord, note 2.
Coke referred to Minerva Mills.
Yes, Lord.
The reverse.
Yeah, the judgment in Minerva Mills was referred to in Sanjeev Coke.
I'm so sorry. So Sanjeev Coke is the other judgment which also deals with this 31C. My apologies, Lord.
Right.
I misspoke. My sorry. So, Lord, we have Sanjeev Coke, then we have Bhim Singh Ji's case. We then have the insertion, Lord, and then, Lord, if your lordship will just kindly turn to where's the order in percent? Lord, just there is one more date which I want your lordship to have. I'll just give it to your lordship presently, my lord. The order in yes, my lord, that is 1986. The exact date.
86 to
13th March 1986. 13th March 1986.
Right.
And then we have finally, my lord, to conclude this, the order of reference from 3 judges to 5 judges on this issue.
That we have seen.
1st May 1996. So, my lord, that is how the issue now arises before your lordship.
Right.
But may I now show your lordship, Lord, the Minerva Mills case?
Yes.
And then I will like to show your lordship Vaman Rao, Lord, before we move further. Lord, so if your lordship doesn't mind, Lord, Minerva Mills. Lord, your lordship will find that at page 2050 of the precedence compilation which your lordships have. Lord, we are principally concerned here, Lord, with the majority view. But, my Lord, Justice Bhagwati actually, Lord, does something quite unusual. My Lord, Minerva Mills, he also deals with Vaman Rao. So, my Lord, may I refer your Lordship first in Minerva Mills, my Lord, straight away, my Lord, to the question for consideration. And that your Lordship will find at page 639. Sorry, internal 639, which is 2064. Your Lordships have that, my Lord.
Chandrachud.
Yes, my Lord. So, my Lord, in the first paragraph, my Lord, the question is summarized, my Lord. My Lord, in Keshavananda Bharati, this court held by a majority that though by Article 368 Parliament is given the power to amend the Constitution, that power cannot be exercised so as to damage the basic features of the Constitution or as to destroy its basic features. The question for consideration in this group of petitions under Article 32 is whether Section 4 and 55 transgress the limitation on the amending power. Then, if your Lordship will kindly notice in paragraph 5, what a curious feature of this case was that the statute in question was actually a pre-amendment statute, as your Lordship will see. By these petitions, the petitioners challenged the constitutional validity of certain provisions of the Sikh Textile Undertaking Nationalization Act and the order dated October 19, 1971. We are not concerned with the merits of the challenge at that stage. And then, my Lord, the way the matter proceeded was on a basis of a concession, which I want to bring immediately to your Lordship's attention. Lord, there is, if I may say so, my Lord, you will find in paragraph 7 to paragraph 12, my Lord, a masterful and clear exposition of the law in Keshavananda Bharati. A judgment which it has been, my Lord, perennially difficult to exactly distill the meaning, but, my Lord, there is a masterful summary, my Lord, which I found very useful in these paragraphs. And then if your Lordship goes straight from there, my Lord, please go to paragraph 24.
At 23 at page
24, my Lord, it is at page 2069. And the point I want to make here, my Lord, is that the entire case proceeded on a concession. As your Lordship will notice, my Lord, I won't paraphrase it, but I'll just read it. The next question which we have to consider is whether the amendment made by Section 4 to 42nd Amendment of the 42nd Amendment Act to Article 31C of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C. So, my Lord, it's very clearly stated.
But they also say, this was, and indeed that could not be done. So they had their own reason, and they had the reason for it. The unamended 31C forms a subject matter of a separate proceeding, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshavananda Bharati. So the unamended 31C was valid for the reason that it was upheld in Keshavananda itself.
It was a subject matter in Vaman Rao.
That's right.
So Justice Bhagwati notes in detail on page 2088.
That's okay.
Very extensively dealt in minority of Justice Bhagwati.
No, my learned friend is right again. Lord Justice Bhagwati is.
Mr. Chandrachud, tell us this, that para 1 of Minerva says that what was challenged in Minerva was the constitutional validity of Section 4 of the 42nd Amendment.
That's right.
Now, Section 4 of the 42nd Amendment comprehended two features. It actually comprehended one feature. Let me begin by saying that. It comprised the entirety of the provisions of directive principles which are now brought in by way of the amendment. So that would include 39B and C and the other principles in part 4 of the Constitution apart from 39B and C. Now the validity with 39B and C was already dealt with in Keshwanand Bharati.
Your Lordship is right.
Right. Therefore, though the entirety of Section 4 was in issue, I guess the problem which the Minerva bench felt was that they couldn't bifurcate the two, because what Parliament had done had to bring in one composite amendment. So they couldn't bifurcate between the 39B and C part and the other parts of the directive principles.
My Lord, I would agree with your Lordship respectfully, my Lord. Because, my Lord, as your Lordship rightly pointed out, my Lord,
Bring it down.
Para 24.
Para 24.
Page 20.
Oh, that's what he was reading actually.
I'm not the
You are reading para 24. That's why, that struck me that Mr. Palkhiwala also doesn't challenge the validity of the unamended 31C. Because it was upheld in Keshwanand. And therefore, though there's a concession by Mr. Palkhiwala, the court says, and indeed that could not be done. They have endorsed it. As we do so many times in our orders, that learned counsel did not, or argued, and correctly so, so that we are lending our own authority to the submission of counsel.
Yes, Lord, your Lordship is right, and it does add a slight complication to the matter. But I believe what
reference, of course, to Vaman Rao, because Vaman Rao was pending at that time.
Lord, so the curious, Lord, in one sense, it comes down to Keshav Nanda.
Reasons had come in July. The operative order in Vaman Rao had been pronounced. May. So they knew that they had upheld the constitutional validity of the unamended 31C in Vaman Rao. The reasons were to follow later in November.
But I would add to that a little bit, Lord. In fact, if your Lordship sees the order in Vaman Rao, it's not exactly in line with the reasoning in Vaman Rao. If your Lordship just comes back, the reason why they said this.
It's a conundrum, because while Minerva sets aside the entirety of Section 4, Section 4 comprises a smaller subset which has been upheld in Keshwanand. The bench in Minerva did not have the ability to say that it was severable, because the severability would not arise, because it was one amendment, it was one substitution, it was composite. Otherwise, they would have severed it. They would have said what has been upheld in Keshwanand, we can't strike it down, but they didn't have that choice here because it was one composite amendment. Otherwise, they could have applied the test of severability. But when you apply the test of severability, something which is valid has to survive. Here, they could not apply the test of severability because it was composite. So, in a sense, that was intellectually the problem which the bench was facing. I mean, they don't articulate it in that way, but obviously it's clear. That must have been that was a. Therefore, they strike down the entirety of Section 4.
Lord, may I add to? Lord, I am complete respectful agreement with everything that your Lordship said. And Lord, I'm glad that your Lordship said it rather than I saying it. But Lord, may I add one or two things that I could say about it, Lord? If your Lordship were to see the order in Vaman Rao, it actually says this. The reason why they actually repeated this in Minerva Mills was that the order in Vaman Rao, which was available by the time that the judgment came in Minerva Mills, for which your Lordship will find conveniently at para 15 of my list of dates, page 19. But it says this, but I'll just read to your Lordship again. 31C as it stood prior to its amendment is valid to the extent to which its constitutionality was upheld in Keshav Nanda Bharati. So the reason why, Lord, they used this very language in Minerva Mills was this was the order in Vaman Rao. But what this meant was actually explained by the judgment in Vaman Rao. But I'll just come to the judgment in Vaman Rao in a minute. Lord, Vaman Rao, Lord, decided on independent reasoning. not on the doctrine of precedent and Keshavananda Bharati, but arrived at the same conclusion. So, my lord, that is how this statement comes to be a part, and that is the correct meaning to be ascribed to the latter part of this concessionary statement.
But then if Vaman Rao independently uphold the unamended 31C,
Yes, my lord.
right? Does
That
it
is
hold it only for the period prior to the 42nd Amendment, or does it then, is it capable of the inference that, well, that the unamended 31C survives the striking down of Section 4 in Minerva?
So, my lord, your lordship has once again, my lord, rightly identified the complication. My lord, as soon as we deal with Minerva, my lord, permit me to go to Vaman Rao. But would your lordship mind if we just finish with Minerva once?
We saw para 24. Let's go ahead. You can go in.
So, 24 is a para, my lord, of considerable importance.
Para 25 also?
25.
Yes, 25 also. But of course, not the whole judgment, my lord, is very...
Zal, you can read para 24.
24 again, please. But I'll read it slowly. The next question, which we have to consider, is whether the amendment made by Section 4 of the 42nd Amendment to Article 31C of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C and indeed could not be done. Now, why could it not be done? The unamended Article 31C forms the subject matter of a separate proceeding, and we have indicated therein that it is constitutionally valid to the extent to which it was upheld in Keshavananda Bharati, and the asterisk
Not a
takes us.
concession.
It's not a
It
concession.
is not a concession at all. It is because there is already a decision of Supreme Court
Yes.
which has upheld the validity of
In Keshavanand and independently in Vaman Rao.
It's an authoritative pronouncement.
It is an.
Lord, I accept what your lordship say. Lord, that yes, it was not Mr. Palkiwala made the concession, but the judges said that on the basis of the concession and on this basis, in fact, the concession was unnecessary because Vaman Rao had already decided this one.
Will it be also right to say that it was a concession by Mr. Palkiwala? Mr. Palkiwala, he said that he did not challenge it. That doesn't mean that, you can put it as if there was a concession made.
he stated the correct position of law. This is what has happened.
So, my lord, yes, your lordships may well be right, my lord. That also works for my argument, my lord. I don't need to dispute that. Yes, my lord, it could well be that what Mr. Palkiwala said, that in view of the order now which is passed in Vaman Rao, I don't need to challenge it, albeit, my lord, I may respectfully differ from your lordship for this reason. But consider the timeline. Lord, at the time when the matters were being heard together, the order in Vaman Rao was not out. During the course of the hearing, the order was not out. Lord, so Mr. Palkiwala, my lord, would not have been able to, my lord, know that in Vaman Rao this would have been the case. But by the time that the judgment is delivered in Minerva Mills, the order in Vaman Rao is out. So the judges have the advantage of that order. So, my lord, the way that I read this, my lord, given this context.
It's almost 4 o'clock, but the only point which we'll have to consider is this. You can reflect on it.
Please.
The net result of Vaman Rao and Minerva Mills is this. Vaman Rao upholds the unamended provisions of Article 31C on reasoning independent from that in Keshwanand.
Well,
the amended provisions of Article 31C, as amended by the 42nd Amendment, are struck down in Minerva Mills. Now, does Vaman Rao really mean that the unamended 31C is upheld only prior to the date of the insertion of the substituted provision by the 42nd Amendment? Or does the unamended 31C continue to operate both before and after Minerva?
Your lordship has put the problem perfectly, actually. Your lordship does know, I think, that my answer would be the first. But, my lord, I'll deal with it, my lord, at some length tomorrow.
Is that clear? Because then what was the purpose of Vaman Rao? Because the unamended provision of 31C had already been upheld in Keshwanand. Right?
Right.
Now, Vaman Rao, they had to deal with then why would they write a judgment in Vaman Rao?
Yeah, my lord, I will show your lordship. Yes, my lord. But let me not say anything, my lord.
Benefit of Minerva. They mentioned.
Lord, I will press your lordship on this tomorrow.
Because see, Vaman Rao, conscious of the fact that they have struck down section 4 of the 42nd Amendment, yet proceeds to hold that the unamended 31C is valid.
That's correct.
Is that not therefore susceptible of the inference that they treated 31C to be continuing in operation, though in its unamended form, post the decision in Minerva?
But I will reflect on that.
Just reflect on it, Mr. Darshana. We'll continue tomorrow morning.
Deeply obliged.
Let's see what was the nature of the challenge in Minerva. You've shown us para 1. With the nature of the challenge in Vaman Rao, we'll also reflect on it in the evening and in the night today and look at it.
Sir, deeply obliged, sir.
Mr. Andarjan, are you headed back to Delhi tomorrow or no?
Yes, I will be, bro.
All right. In physical presence hearing tomorrow.
Yes. Yes. All right. Yes.